Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Afternoon. Today is Thursday, April 23rd, 2026. How's everybody doing today? Quick pivot. I forgot. It wasn't in my calendar for some reason. But at 2 p.m., there is a hearing, a Karen Reed hearing, in which she will, I imagine, be at this hearing in Norfolk Superior. They're still fighting to get Michael Proctor's phone extraction in the Myles King case. So we're going to cover that live at 2 p.m., which may prevent us from covering the Lindsay Clancy hearing at 2 p.m. That conference is only on Zoom, and it's really just a status conference on where they are with obtaining Lindsay Clancy's, I think, her medical records. And so, due to popular demand, we are going to pivot and cover the Proctor phone hearing at 2. I didn't have time to change the thumbnail, so tell your friends if anybody wants to watch it. That's what we're doing at 2. It's Rosemary Scapiccio, our spirit animal, coming in hot for Myles King. And so that's going to be good. So we're going to watch it. That'll be great. I want Lally back on the stand too. I don't know if, when, if ever that will happen. Ever. I don't know. But go Avs. Got my Avs cap on today. Bruins at 7. Avalanche at 10. And I love playoff hockey season. Is anybody else watching? Does anybody else care? Or is it just me? It's okay. Because I'll talk about it anyway. Because you're going to listen to what I talk about. Wow. Yesterday, we finished part 4 of the Aidan Carney Karen Reed lawsuit filed by the Haas defendants, Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. And it took, I don't know how many hours to do that. I don't know, between 18 and 20 hours, I think, because they filed a 50-page long complaint, and there was a lot of footnotes in there. And so if they want us to look at the footnotes, we're going to look at the footnotes. The footnotes included YouTube presentations of Aidan Carney, news clips from various news organizations, parts of Karen Reed's second trial, including Hank Brennan's closing argument. We didn't watch the whole thing, but we watched the clips that he played during his closing, in which Karen Reed had given some statements to some news organizations. We read some Turtle Boy articles, and boy, did we learn so much more than I knew. Many of you. Oh, we watched a Canton Select Board meeting in which Chief of Police of Canton, Helena Rafferty, told the public that, yes, indeed, it was true that John O'Keefe had reported drug dealing in his One Meadows neighborhood before his murder, and that there was extensive correspondence between John O'Keefe and the detective unit at Canton PD. And you guys were telling me that Canton PD detective unit is only Kevin Albert. I don't know if that's true or not, if you were just joking. But we haven't seen that correspondence. And people that have tried to FOIA that correspondence between John O'Keefe and Canton PD have been told that the investigation is ongoing and they can't have it. So, wow. We learned so much more than we did. And we saw some videos of Aidan Carney outside the courthouse during Karen Reed's, I don't know, second trial, where he was being kind to babies and supporters. And it showed a different side of it. Aidan Carney is a different personality, in my opinion, in many ways than Turtle Boy, than the persona of Turtle Boy. And seeing him that day outside the courthouse and the love that he got from all of those people who came from all over the country. And somehow the Haas defendants want the world to believe, and the court, and a jury, to believe that all of the attention on them and all of the things that people think about them are because of Aidan Carney and his collusion with Karen Reed, his civil conspiracy with Karen Reed to get out this false narrative that they were involved in. What I'm finding out by talking to you and watching the comments and reading the chat is that so many of came into the Karen Reed trials not even knowing who Aidan Carney was. Many of you have written me and said that you did not even know who Turtle Boy was until his name was mentioned at trial number 1. And that's when you learned who Aidan Carney was. And so many of you have told me and each other that you came to your own conclusions about the truth and veracity of the witnesses that are suing Karen and Aidan, Jen McCabe, Brian Albert, Brian Higgins, Colin Albert. You came to your own conclusions about their potential involvement by watching the trial. You're not easily brainwashed. I know you. I have the smartest chat on the internet. I did see that Aidan was on Billy Bush this morning. You guys should go back and watch that later. It was good, very good. And I know that many of you can think for yourselves, but what they want you to think is that you've all been brainwashed. They want the court to think you've all been brainwashed by Aidan Carney, which is kind of interesting and funny because I know how smart you are. On top, thank you for your super sticker. You don't get easily brainwashed. And we also saw by going through all of those footnotes how thorough his research was and how he had receipts for everything he ever said. And we also think that, or I think that he absolutely 100% believed that everything that he was saying was true because of his research and because of his deductive reasoning skills and his reading of the court file and watching, just like we all did. But he started reporting on the Karen Reed case in April of 2023 when the 227 search became public. That's when he said he became interested in it. And what is so interesting about that is that we learned yesterday, because they pointed us back to it in one of the footnotes, Kerry Roberts' testimony in trial number 2 when she was crossed and caught in the lie that she told to the state grand jury in April of 2022. I think it was April 26. I said it wrong yesterday. I said April 6. It was April 26 of 2022. Kerry Roberts told the state grand jury that was convened to upgrade Karen Reed's charges to murder. She told the grand jury, and Adam Lally asked her a very specific question and asked her about something that you heard. Was there anything that you heard while you were praying and standing outside the car? And she said, I heard, and not exactly, but I'm summarizing. Karen asked Jen to Google hypothermia, how long hypothermia. And on cross, she admitted she never heard her say that, but she just knew that it happened, and that's why she testified to it. She just knew. Use your deductive reasoning skills. Aidan didn't start reporting on that case until a year later. Why was it that Kerry Roberts was asked about that during the grand jury? And why would she not tell the truth? She knew that it happened. How did she know? She didn't hear it. She knew it happened because Jen McCabe told her. The fix was in my opinion. Thank you, Venus Blue Cupcake, who says, love you so big. 1 month till our 1 year anniversary. Oh, Cupcake forever. Thank you, Venus Blue Cupcake. Appreciate you so much. Rolling in the Steep says, love you. First time catching you live. Oh, well, welcome. I'm so glad you're able to be here live and participate in the chatting. I think you're going to like it here. The chat is called the Snark Tank for a reason. So if you can make me laugh, please do. Please do. Because covering that mishigas of a lawsuit, the defamation lawsuit for over almost 20 hours, exhausted me. And I wasn't going to do anything today, but then there's so many things to do and catch up on. I have for you already queued and pulled up some heinous, horrific new filing by the government in the Matthew FARWELL case. I have, which even makes Matthew FARWELL, if it's possible, to be even more of a monster, in my opinion, than many believe him to be. He is, as you know, being currently held in federal lockup for the murder of Sandra Birchmore and her unborn baby, innocent until proven guilty. But ask yourselves that too. All of those people out there that are simping for Michael Marcy, how great Michael Marcy is, how he's the greatest thing since sliced bread. And yet he never brought state charges against Matthew FARWELL after he was quickly cleared, despite mountains of evidence against him, for what they called self-deletion, or I can't even say that in the first, that they all concluded, Canton PD and the Massachusetts State Police detectives assigned to the case, that Sandra Birchmore took her own life, when in reality, he's now facing federal charges. And that's what the feds do. Sometimes they file federal charges to hold a guy, thinking that the state's going to pick it up. And then, of course, it can go back to the state. Well, the state never did that. Michael Marcy never did that. Fanning was involved. Tell me who else was involved in the Sandra Birchmore investigation. So there's a lot going on. And I think what we'll do, since we have a little bit of time, is that's only a 4-page, it's a 5-page document. I'm going to read it to you. Much of it is redacted. I am not going to read it. You can try and figure out what's underneath the red portions that I've redacted, because it's repulsive. It's about his corn searches and such. Matthew FARWELL is asking a federal judge to release him from jail and let him out on bail pending his trial, which is coming up. I can't remember the exact date. I had Pacer pulled up before, but I think it's sometime in the fall. The government, the United States of America, is opposing Matthew FARWELL's getting out on bail because they believe that he's dangerous. Thank you, Martina. If I'm not busy, I just don't even know what to do with myself. She says, you're doing so much good. Bless you. I'm busy all the time. Thank you. So let's take a look at that, and let's go over that quickly before Karen Reed's hearing starts. So at least we'll knock one thing off the docket right now. Oh, honey, I am that Gigi. Thanks, Gigi. Gigi gifted 5 memberships because she's freaking awesome. Very recently, we read the government's response to this motion for ask for FARWELL getting out on bail. And they're like, yeah, no, he's dangerous. Here's why. Gave a bunch of reasons. Go back and watch that show. It wasn't that long ago. But here is the government's second supplemental memorandum in support of detention for Matthew FARWELL. I didn't even have time to put my show notes in today. So for those of you who aren't familiar with the Sandra Birchmore case, I have an entire playlist on it. And Sandra Birchmore was murdered allegedly by Matthew FARWELL when she was pregnant back in February of 2021. She lived in Canton. She was found in her Canton apartment, hanging from a doorknob. We learned during the last opposition from the government that Matthew FARWELL's DNA was found on the strap used to hang her. And also his seminal DNA was found inside of her underwear, which I didn't even think of the last time that when we went over those papers initially, but that begs the question, doesn't it? Did Matthew FARWELL go over there for one last romp before he took her life, which was the same night that his wife was giving birth in a nearby hospital? He's caught on video camera in her apartment building lobby. Interesting too, because he was wearing a mask. You know, it was like post panty, and he was a very, from what I understand, anti-masker, and he was wearing a mask in that video, right? Tully, Buchanan, Garino, they were all involved. I know Garino was in charge of the phone extraction. Let's get through this because it's revolting. But we learned through the last filing of the government that his DNA was found on the murder weapon and in her underwear. And I'm revolted. And we've also learned throughout the course of discovery here that Matthew FARWELL was not the father of her unborn child, even though she told him that he was, and she might have thought that he was. He wasn't. Moving on. Let's read it. Government second supplemental memorandum in support of detention. The government submits the second supplemental memorandum in support of its motion for detention in order to incorporate evidence recently obtained by the investigative team. Need my highlighter? Highlighter? Yeah, okay. In August of 2024, the FBI seized an Apple iPhone that belonged to defendant Matthew FARWELL pursuant to a federal search warrant. We also learned during the last filing that nobody ever sought to get a DNA sample from FARWELL, Canton PD or MSP, because first of all, they never asked for it. They never even tried to get it, or they asked for it and he just said no. And they're like, okay, no big whoop. I think that's what happened. Yeah, no worries. You don't need to give it to us. You're cool. Even though they found DNA on the murder weapon and inside her underwear. So it's beyond. It's another inept, incompetent, cover-up, corrupt investigation in Norfolk County. Okay? So it goes a lot deeper than Karen Reed. But in August of 2024, the FBI seized his iPhone pursuant to a federal search warrant. Out of an abundance of caution, the government agreed to permit the defense team to conduct a review of the seized data to identify and withhold any potentially privileged material before disclosing the remaining data to the government's investigative team. Well, I mean, the U.S. attorney really trusted his lawyers. On April 6th of 2026, FARWELL's counsel provided the government with a filtered version of the iPhone data. It took almost 2 years. While FARWELL's attorneys have withheld more than 80,000 communications, 80,000 communications have been withheld. A preliminary review of the filtered data they have disclosed has yielded new information that was not available to the government when it filed its supplemental memorandum. So they just got this in between their last filing and the day this was filed, which was, I think, yesterday. This new information, which is described in more detail below, is probative of FARWELL's risk of flight and obstruction and the profound danger he poses to the community. Okay, so those are the things that the court needs to weigh when deciding whether to let somebody out on bail. What's the risk of flight, or that he could obstruct, or that he could, try and intimidate witnesses? And is he a danger to the community? And we learned a lot about danger to the community in the Kelsey Fitzsimmons case. Footnote 1. The government also submits under seal, as Exhibit 16, a letter from victim Sandra Birchmore's family expressing their opposition to the release of the defendant. First, FARWELL's iPhone data reveals that in 2021 and 2022, after Sandra Birchmore's death, his devices accessed pornographic material that suggests that he maintains an S-type interest in teenage girls. Remember in the last filing, we also learned that even though it was not made public, that she was found hanging from a doorknob, that he did reenact that scene at a cocktail party when he was hammered. Yeah, I remember. On November 21, 2022, remember she was killed February 2022. February of 2021. But he wasn't arrested until 2024. On November 21 of 2022, FARWELL's phone accessed a pornographic video titled "Barely Legal Teen Gets Blank from Stepdad." This video is approximately 23 minutes long and depicts a young adult-looking female, petite in stature with slight breast development, engaging in P and V intercourse with an adult male. Throughout the video, the phrase "teen gets blanked" appears in capital letters in the bottom right-hand corner. Farwell's device also accessed pornographic videos with the following titles: Shocked and Impregnated, videos targeting effed up family teen, and teen stepsister moans, don't you dare blank inside blank. Footnote 2, and that is an exhibit with these Google searches or pornographic searches that have been sealed. Farwell's post-offense interest in the foregoing material is relevant to the court's determination of whether Farwell poses a risk to the community. As set forth in the affidavit in support of detention, the evidence indicates that Farwell took Birchmore's virginity in April of 2013 when she was 15 years old and enrolled in the Stoughton Police Explorers program. At the time, he was a 27-year-old police officer instructor. During the course of their relationship, he would often require Birchmore to pretend as if she were 13 or 14 years old during sexy time, or pose as his sister and simulate non-consensual brother-sister relations. And we learned about this. We knew about this a while ago. Some of this was in Sandra's communications. Farwell's enduring sexual interest in teenage girls, even after Miss Birchmore's murder, is a critical aggravating factor that courts consider. Cameras up in Norfolk, but we're not ready to go there yet because they're not starting just yet. We have about 8 minutes. It's a critical aggravating factor that courts consider in determining whether a defendant poses a danger to the community. Here, this new evidence that Farwell maintains an interest in the sexualization of teenagers should weigh heavily in favor of detention. Keep him in jail where he belongs. Second, Farwell's iPhone data includes additional evidence relevant to the court's assessment of the risk of obstruction. While Farwell accessed most websites, including pornographic websites, using his phone's default internet browser, he used DuckDuckGo to conduct internet searches for Sandra Birchmore and other information related to her death or the investigation. Footnote 3, which tells us that, see Exhibit 17, which is going to be sealed. DuckDuckGo enables users to browse internet sites while shielding their browsing history from third parties. Farwell's affirmative efforts to hide his internet activity related to Sandra Birchmore underscores the difficulty of finding conditions that will ensure that Farwell, a somewhat tech-savvy former police officer, does not take steps to further obstruct the investigation and trial. Third, Farwell's iPhone data contains additional evidence of risk of flight or non-appearance. On June 24th, 2024, the day that it was widely reported in the media that Dr. Michael Bodden, footnote 4, concluded that Birchmore died by homicidal strangulation, Farwell wrote a message in his iPhone's Notes app to a close friend. Footnote 4 reads, Dr. Michael Bodden is the former chief medical examiner of New York City and former chief forensic pathologist for the New York State Police. He was retained by Ms. Birchmore's estate to determine her cause of death, right? Because there is a civil suit pending for wrongful death by Sandra Birchmore's family against Farwell and others. Footnote 5 says, see Exhibits 18 and 20, pending motion to seal. In that note to his close friend, he tells his friend that he wishes this had all gone a different way. Farwell asks his friend not to forget his wife and to step in and raise his children. He indicates that, quote, this is the hardest thing he has ever done, and that he would see his friend on the other side. While the note contains several self-serving false statements, it is probative of Farwell's state of mind regarding his intent to flee or otherwise not appear for trial. Farwell took no steps to flee, nor are there other notes like this written during the 3.5 years that he believed he had gotten away with the charged offenses. Yeah, murder. However, Dr. Bodden is also married to Linda Kenny Bodden of Justice Served TV. However, when Dr. Bodden's report was published, it was the first time that an expert had publicly opined that Birchmore's death was not a suicide. And the data from Mr. Farwell's phone reveals that is when his relevant state of mind changed. Courts have held that ideations like those expressed in Exhibit 20 can constitute a risk of flight or a risk of taking one's own life, right? For the reasons stated herein, as well as those in the government's other memoranda in support of detention, the government requests that the court order defendant Matthew FARWELL detained pending trial. The government further requests that if the court is inclined to release the defendant on conditions, it stay the order for such time to permit the government to file a motion for revocation of the order of release under the United States Code. XOXO, Leah Foley, U.S. Attorney, by Elizabeth Riley, Brian Fogarty, and Tori Cummings. And this was just filed yesterday, the 22nd. They're telling us everything, aren't they? They better keep that mofo locked up. I mean, yeah, innocent until proven guilty and all, but is this just another something that the cops in Norfolk County and Massachusetts State Police tried to cover up? You tell me. You can come to your own conclusions, but that is revolting. I'm revolted. Are you? They're in the big room today in Norfolk Superior. I wonder if there's going to be a lot of people in the gallery. Well, I'm going to mute it until they get started because the background noise is a little distracting. Yeah, he was part of the Police Explorers program, which was a program run by the Stoughton PD for kids who wanted to become police officers. Sandra Birchmore was, I think, 11 maybe when she joined, and they were in positions of trust, and she was passed around like a toy between Matthew FARWELL and his twin brother and Robert Devine, who was the head of the program, another cop, and another guy, maybe, who was like town animal control guy. Heel, his name was, I think, right? Joshua Heel. All right, they're filing into the courtroom. This is the Karen Reed Proctor. Oh, it's Judge Doolin. It's Judge Doolin. And this is in the Myles King case.
I saw Mr. Attorney Cataldo outside. He's not here yet. Going around it. And I haven't seen Mr. Krowski. I have not seen Mr. Krowski. I can text him. Would you like me to do that?
Rosemary Scabiccio.
Okay, he's before the court, or you want to step up?
I'm going to let it modulate before I boost it because it takes a minute. I don't see Lally there. Where do you see Lally? In the gallery? Play I Spy. Oh, is that Lally over there? Oh, look on the right near the window. Is that Lally? I Spy Lally? It's hard to say, but it could be.
Just text him here. I'm just waiting for him to text back. Okay.
Judge Doolin, what a pleasure. There's Bill Reed, Janet Reed, and Karen Reed. And Margaret. What a treat. Margaret, our favorite court clerk. Judge Doolin, there's Karen. Looking good. Per usual. They're going to take some other cases first. There's Karen and Bill and Janet getting some FaceTime from Boston 10.
On his way, Madam Clerk, I advise the judge.
presence is waived. We appreciate the coroner here. What would you like to come back?
We talked about Madam Clerk.
This is a different case that's happening right now.
Either June 25th or June 30th.
You want to put it into July for a lobby conference?
Sure. So Judge, we'll stay away from the 4th of July. The week after, I can do 6th, 7th, or 8th.
That's all fine.
We're available all of those days.
7th is Tuesday. Thank you, Your Honor.
Thank you. Have a nice day.
So which date did you choose?
Tuesday?
Tuesday the 7th?
Yeah, that's right. Thank you.
So Mr. Busby's case is continued to July 7th at 2 p.m. for a lobby conference. Thank you.
Mr. Cosby's talking, he should be here momentarily.
Okay.
And then the other piece
There is a banner scrolling along the bottom. If anybody comes in and says, what is this? What is this? It's scrolling right along the bottom. I don't know why Lally is there. Remember, Lally was in the middle of testifying at an evidentiary hearing in this exact case when the plug was pulled on it. And we wanted him to testify because Myles King made a motion to dismiss because the Commonwealth didn't turn over certain discovery. I don't know if he's going to testify, but he's in the courtroom.
Either today or tomorrow or something, we can go on the record. Maybe I'll talk to somebody about that. No, he's going to stay.
What are you talking about? You can't see the banner or me? What are you talking about?
No.
I can see me and the banner.
We'll try. Yeah. I don't think so. Unless something changed.
Maybe it's your device. Maybe you have yourself zoomed in. There's a Bruins jersey over there on the left side. If it's buffering, you need to refresh your browser. YouTube's having some glitches lately. Yes. Doolin is the one that says, Mr. Bettero. Here's Joe Krowski coming in with that yellow tie. You might recognize him from his appearances on Court TV, in which he really
Krowski, how you doing?
You were on the bench at 1:59.
Hey, well, it was 2:03 you came in. It means you're 4 minutes late.
Next, for the court numbers 1, 2, 3, and 4. Number 1 is Commonwealth versus Myles King, 21 CR 320. Mr. King is present and represented by attorneys Rosemary Scapicchio and Nicole Scapicchio. Also before the court, Commonwealth number 2, Commonwealth versus Bianca Chanchio, 22 CR 265. Ms. Chanchio is not present. Her presence is waived by her attorney, Joseph Cataldo.
Yes.
Also before the court, Commonwealth versus Giovanni De Los Santos, number 3 on today's list. Mr. De Los Santos is not present. His presence was waived by his attorney, Joseph Krowski Jr. And finally, before the court, number 4, Commonwealth versus Sean Johnson, 22 CR 268. Mr. Johnson is present and represented by attorney Rosemary Scapicchio. For the Commonwealth, we have Melisa FARWELL and Pamela Alford. And if the parties, and for Michael Proctor, we have attorney Tom DeGangi, and for Carrie, we have attorney Aaron Rosenberg. If the parties could please all identify themselves for the record, beginning with the Commonwealth.
Good afternoon, Lisa Beatty for the Commonwealth.
Good afternoon.
Good afternoon, Pamela Alford for the Commonwealth.
Good afternoon.
Attorney Joseph Krowski Jr. on behalf of Giovanni De Los Santos.
Okay, hi.
Good afternoon, Rosemary speaking on behalf of Mr. King and on behalf of Mr. Johnson.
Okay.
Good afternoon, Your Honor. Nicole Scapicchio on behalf of Mr. King and Mr. Johnson.
Good afternoon, Your Honor. Aaron Rosenberg on behalf of third party Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Tom DeGangi on behalf of third party Michael Proctor.
Hi, Mr. DeGan.
Joseph Cataldo on behalf of Bianca and Chanchio.
Okay, good afternoon, Mr. Cataldo. I'll start with counsel for Ms. Reed. Go right ahead. I've read the briefs. and I'm familiar with the history of what's happened with this phone. So go right ahead.
Understood.
This is on something you haven't filed yet, right?
Say that again?
This is on a suit that you haven't filed as of yet.
This is a suit that we are going to file within the coming weeks as soon as the presentment period expires.
Okay.
So it was mentioned in the suit that we filed, and we said we were going to file it once that period expired, and that's the same suit that we're talking about.
Okay.
Because of some machinations and procedural things, that now has to be a whole separate lawsuit because the other lawsuit we filed was removed to federal court where we can't sue the state police. So it's going to be a separate case as of the next few weeks. But what we're seeking here, Your Honor, is actually a minor procedural amendment to the order that you issued last time we were all together. And it's an amendment that will have zero practical impact. As of today, according to the court and the Commonwealth and the parties, Ms. Reed may already use these communications from Mr. Proctor's private cell phone for any purpose in the pending O'Keefe litigation. And they're subject to the restrictions that we all agreed upon and that Your Honor accepted. So if we wanted to or needed to, we could today file these documents that we're talking about. All that we're asking is that we have permission from the court to do the same thing we're already allowed to do in the pending litigation in Plymouth, in the O'Keefe litigation, in the complaint that we file, and also in Superior Court, and we are agreeing that it would be subject to the exact same restrictions. The only change to our agreement with the Commonwealth and your order would be adding one other litigation that it could be used in. But again, another Superior Court litigation. This request is necessary because the communications are highly relevant to the negligent hiring, supervision, and training claims that Ms. Reed is bringing against the Massachusetts State Police, as well as the town of Canton, which she's going to do in a matter of weeks, as I just told Your Honor. And these relate to primarily Mr. Proctor, as well as Canton Police Sergeant Sean Good. These messages contain images of, as is already in the record and as the Commonwealth has said, and information about women that appear to be unrelated to the people in the conversations and likely unaware that they are contained, these pictures or messages are contained within this data. We've already agreed that that is subject to strict confidentiality provisions. We are not able to use those unless we come to you and ask, and we are not asking for that right now. What we're asking for is the messages, primarily the messages written by Michael Proctor and Sergeant Good of the Canton Police. But now the Commonwealth, in its opposition to this procedural motion, is attempting to tell Ms. Reed, a private party in civil litigation, what she does and does not need or get to use in the complaint that she's going to file. There is nothing in the rules, the law, or anything else that gives the Commonwealth the right or the ability to do that. And this is not premature at all. Ms. Reed does not need to wait according to any rule or law. She does not need to wait until discovery to use evidence and communications that she already knows about. So frankly, it's unclear why the Commonwealth is joining with Mr. Proctor to oppose this motion today. These existing restrictions are more than sufficient to protect the legitimate confidential images of women or other people that are not Michael Proctor, are not Sergeant Good, are not otherwise relevant. But the only reason why we need to even come to you today is because when Ms. Reed tried to add these claims to the existing O'Keefe case, a number of parties and third parties objected and opposed that, and she was unable to bring those claims in the existing case. If that hadn't happened, this wouldn't even be necessary. We'd already be able to use them. Now, as opposed to the Commonwealth, Your Honor, it's very clear why Michael Proctor opposes this motion. As we said in our papers, these communications are not private, they're not personal, they're not confidential, and they're not privileged. But what they are is staggeringly anti-woman, racist, homophobic, anti-Semitic, among other things. And that description applies to messages from both Mr. Proctor and Sergeant Good of the Canton Police Department.
Well, we're learning a lot more about what was in Proctor's phone about Sergeant Good that caused him to be suspended. Anti-woman, anti-Semitic, racist. Go on. This is Aaron Rosenberg. He represents Karen Reed in her civil cases. They've made a motion in the Myles King case, and he says, we don't even have to make this motion. We're allowed to use it anyway. We don't need your permission. But the Commonwealth is not allowed to tell us what we can and can't use. They are not the gatekeeper here, Your Honor. Something about nudes, I'm imagining, intimate photos of women who are not in the conversation between apparently Proctor and Sergeant Good. It's all coming out now. They're telling us everything.
So it's understandable why Mr. Proctor wants to keep that secret, but he has no right or basis to do so. As a reminder, and I understand you're aware of the history having been involved, but Ms. Reed only has access, Ms. Reed and other defendants only have access to this because the court ordered the Commonwealth to get this phone and to conduct this review. According to Mr. Proctor's own counsel, between the time that the phone was returned to Mr. Proctor by the Commonwealth and counsel was engaged, he conveniently lost that phone. So this is the only way that these documents are available. In this opposition, he just rehashes the same arguments that Your Honor rejected in the prior motion where we were aligned with the Commonwealth. They're not private, they're not protected messages. These are messages he shared with his group chat of friends. And he also now triples or quadruples, I've lost count, down on the argument that the court should restrict use of his own chats, his own messages, because he chose to share images and private information relating to third-party women with his friends. He wants to restrict use of that now to protect those women's rights. I think the absurdity of that argument is clear. In a normal civil case, there would be no question that Ms. Reed could use these documents in her coming complaint, but obviously this is not any civil case. We recognize that. So we're here again, seeking the court's permission to do so again, subject to the exact same confidentiality provisions that everyone has already agreed to.
Okay, and so you're talking about the February 26th order on the O'Keefe versus CC Hospitality, that same order that I issued?
Correct.
Okay.
And the only change would be adding
this matter here.
Correct.
Okay, let me hear from Mr. Proctor's counsel. Go right ahead.
Your Honor, the plaintiff purports to bring a claim under Chapter 258 for negligent hiring and supervision, not against Mr. Proctor, not against Sergeant Good, but against Mr. Proctor's employer, the Mass State Police. The documents that you ordered produced in February of this year are text messages and images from a private cell phone. It's a matter of public record that back in January and February of 2022, and well prior to that, the Mass State Police did not have any policy or procedure governing the use of private cell phones by their troopers. Okay, so if he wants to bring a negligent hiring claim against the Mass State Police, there's no way, and the plaintiff doesn't allege this, or excuse me, Ms. Reed doesn't allege this or plead it in her motion, that the Mass State Police could have known about these text messages on a private cell phone, should have known about these text messages on a private phone, or through the reasonable use of discretion would have ordered a Mass State Police trooper to turn over his private cell phone after working there for 12 years.
You know what's so funny about that, counselor, is that in some of these group text messages were Proctor's supervisors, Fanning and Tully. So yeah, that's kind of funny. They all knew and they did nothing about it, except heart some messages and thumbs up some messages. No nudes yet. Well, apparently there were a lot more nudes than we knew about. I know he's got a baby shark hairdo too.
In fact, Your Honor, I'm not aware of any employer in the Commonwealth, or perhaps even nationwide, that orders their employees to turn over their private cell phones before they're hired or after they're hired. That would be tantamount, with all due respect, Your Honor, to the trial court or the governor putting you on the bench saying.
You know what else we learned in the deep dive that we just did is that MSP gives their troopers the option to use their own cell phone instead of a state-issued phone. So yeah, your argument is not great. And it's disingenuous. Thank you.
I want to look at your cell phones. It just doesn't happen, Your Honor.
Let's see how boring I am.
Secondly, Your Honor, there are privacy interests here. In footnote number 2, I believe, of Ms. Reed's motion, she recognizes, and Attorney Rosenberg just said it right now, these text messages and these alleged photographs are unrelated to the Karen Reed case. What relevance can they have to
Really?
a negligent hiring, training, and retention
Supervision.
claim
Negligent
against
supervision.
the Mass State Police, when Mr. Proctor is not even a named defendant in that lawsuit? Moreover,
But he is the named defendant in that lawsuit. It's already pending. Where have you been? Hello, sir. It's in federal court. It's pending in federal court. What are you talking about? She can't sue Massachusetts State Police in town of Canton in federal court. So that's going to be another lawsuit. But he is a defendant in the federal case. Is this his first day? I feel like I could do a better job for Proctor than he's doing.
Your Honor, if you read Exhibit 1 to my opposition, it's a 17-page opinion by Justice Krupp.
Yeah, I read it.
Okay.
Yeah, I read
So you saw in there, Your Honor, that Justice Krupp back in November 2023 had serious concerns about the privacy interests that were being brought upon by Miss Reed's followers, okay? Cell phone calls to Michael Proctor's wife, posting Michael Proctor's wife's cell phone on a public forum, posting the name of her employer on a public forum, posting her employer's phone number on a public forum, and encouraging Miss Reed's followers to bombard the employer. What is going to happen? I'm not aware, Your Honor, and I'll say this frankly, I'm not a party to the wrongful death case down in Plymouth. But if there's no confidentiality order in that suit, there's nothing protecting any person from using this information and going after Proctor, the witnesses, the House defendants. You may be aware that just about a week ago, the people that lived inside or that were inside 34 Fairview Road in Canton on the night of this murder actually filed a defamation suit against Miss Proctor. Now,
Wait, against Miss Proctor? No, against Miss Reed? Did he just use air quotes when he said murder? Hold on. I've been trying not to rewind, but his use of air quotes here and his little baby shark hairdo, like when your kids do this in the bath with their bubble bath, when your babies do that, baby shark hairdo, he's too old for that. Did he say murder? Turtle Boy. He hasn't said the Beetlejuice word yet, but he means Turtle Boy, I think. Turtle Boy bad. Judge Doolin knows all about Turtle Boy. Judge Doolin knows this case pretty well. Listen to this again.
just about a week ago, the people that lived inside or that were inside 34 Fairview Road in Canton on the night of this murder actually filed a defamation suit against Miss Proctor. Now, what's telling, Your Honor, is I came across some information that I did not have at the time I filed my opposition. And it's a motion in opposition to a motion to compel, strike that. It's an opposition to a motion to compel filed by the town of Canton on a motion to compel brought by Attorney Rosenberg. Attorney Rosenberg and Ms. Reed are seeking the personnel files of Sergeant Good. And this was filed about 3 weeks ago on the docket. And the town of Canton alleges that when they received this original keeper of record subpoena for Sergeant Good's personnel file, the town of Canton turned over a one-page document, which was a letter putting Sergeant Good on paid administrative leave. And according to the town of Canton's filings, that decision had nothing to do with the Karen Reed case. However, according to page 2 of that opposition, the town of Canton...
Wait, didn't they say the investigation is still ongoing? Somebody said that, did Proctor just hire him an hour ago? I don't know.
Attorney states, on or about December 12, 2026, town council produced to defendant's counsel a copy of the notice of placement on paid administrative leave letter issued to Sergeant Good. Immediately after the letter was produced to the defendant, copies of the letter were posted online. Within 24 hours, someone leaked it to the press. You've got nude photos allegedly in this case that they want to reference, might make reference to in this litigation. You've got the privacy.
Well, now we know they're nude photos. Earlier, Rosenberg just said intimate, but now we know they're nudes. Now we know that Proctor and Good maybe had a history of looking for nudes in suspects' phones and passing them around. I still want to know if there's any nudes of Anna Walsh, Katie McLean, Sandra Birchmore, and others. But thank you for telling us they're nude photos.
You've got nude photos allegedly in this case that they want to might make reference to in this litigation. You've got the privacy interests of witnesses. You've got the privacy interests of victims. None of this is relevant to a negligent hiring, retraining, and retention claim against the Mass State Police.
Supervision.
I would also state that there's no joinder here between myself and the Commonwealth. We didn't join motions. I filed my own separate opposition. I just want to clear that up. There's no agreement between us. So based on all that, Your Honor, I think Mr. Proctor's been through quite enough here. I'd state to the court, Your Honor, that this is a gentleman.
Mr. Proctor has been through quite enough here, Your Honor. We need to show some mercy to disgrace, dishonorably discharge former Michael Proctor. He's been through enough here. I wonder if Doolin's going to laugh out loud. Hold on.
Agreement between us. So based on all that, Your Honor, I think Mr. Proctor's been through quite enough here. I'd state to the court, Your Honor, that this is a gentleman who committed 12 years of his life as a Mass State Trooper. During those 12 years as a Mass State Trooper, he was evaluated every single year by his supervisors. He was never disciplined. He never received a letter of warning, was never suspended. He worked 40 hours a week, keeping drug dealers away from our kids' school.
Oh my God, stop. Was it Tully's audio of the investigative affairs interview or Fanning's that said that they were not allowed to discipline Michael Proctor because they had to sign an NDA and they weren't allowed to tell Michael Proctor or anyone else that they knew what was in Proctor's phone that they discovered, that he testified to in front of the federal grand jury in February of 2024 when they ran over to his house to do the in-person wellness check on him because they were so worried about him. It was Tully. Thank you. So maybe he didn't hear about that or watch that. That's the reason that he was never disciplined, because he signed an NDA.
Listen to this evaluated nonsense. Every single year by his supervisors. He was never disciplined. He never received a letter of warning, was never suspended. He worked 40 hours a week, keeping drug dealers away from our kids' schools, murderers away from our family, rapists away from our children. It's well known, Your Honor, that after these...
Except for Matthew FARWELL. Say no more. Say no more. I don't know if Proctor was involved in that, but we do know there were other Massachusetts State Police troopers involved in that. And we just read the recent motion by the government against Matthew FARWELL and what was going on there. So yeah, talk about how he's protecting rapists. Look, oh my God, my freeze game is so on point. Keeping drug dealers off the street.
Dealers away from our kids' schools, murderers away from our family, rapists away from our children. It's well known, Your Honor, that after these records came out, his cell phone texts, which he openly admitted in court that he sent.
He had to.
After they came out, the Norfolk District Attorney's Office investigated him. The Mass State Police investigated him. And according to the special prosecutor who uttered an open court, perhaps this one, on March 4th, 2025, a federal grand jury investigated him and closed the investigation.
Wait a second. A federal grand jury investigated Proctor? Is he telling us something that we did not know? The special prosecutor said that. Who are you talking about? Cosgrove? Mello? A federal grand jury investigated Proctor? Hold on. Hank Brennan? Hold on. Let me hit this again. We don't know what they were investigating.
Investigated him, Your Honor, that after these records came out, his cell phone texts, which he openly admitted in court that he sent. After they came out, the Norfolk District Attorney's Office investigated him, the Mass State Police investigated him, and according to the special prosecutor who uttered an open court, perhaps this one, on March 4th, 2025, a federal grand jury investigated him and closed the investigation. This is nothing but a fishing exhibition, Your Honor, and I think it should stop here. Thank you.
It's a fishing exhibition. There's an exhibition going on. It's about fishing, and they're telling us everything. No, it's a fishing expedition, not exhibition. And I am not aware that the Norfolk DA's office investigated Proctor. He said that. The Norfolk DA's office, the Massachusetts State Police investigated him, and a federal grand jury investigated Proctor, and some special prosecutor on March 4th of 2025 let that spill in open court. Was it Brennan? I don't know. Okay. I want to go to the fishing exhibition.
2025, a federal grand jury investigated him and closed the investigation. This is nothing but a fishing exhibition, Your Honor, and I think it should stop here. Thank you.
Thank you so much. All right, why don't I do this? I'll go to the Commonwealth last. Why don't I start with Attorney Scarpiccio? I'll go to Mr. Krowski and then Mr. Cataldo. Attorney Costa, are you still part of this, or is your...
I am not. I'm just
Okay.
right today.
Nice to see you.
I wish I was.
Okay,
We miss you.
Thank you.
go right ahead.
Good afternoon, Ron. So we don't really have a position with respect to anything that's going on here.
Yeah.
We're here for two reasons. One, because again, we want to explain to the court that this protective order is ridiculous. He doesn't meet any of the conditions for which a protective order should issue. He's not a victim. He doesn't need protection. No one has threatened him. He says some vulgar, disgusting things that apparently repeatedly from 2014 to 2022, and shares it with his friends like it's please pass the butter. That's the tone of these conversations, Judge. And so the protective orders, for my purposes, are interfering with my client's ability to get a fair trial. Right now, my client, Mr. Johnson, is housed at the Norfolk County House of Correction. We moved mountains to get him access to what we call the Proctor materials. And right now, there's a 44,000 page report that comes from his phone. And there's additional information, close to 70,000 documents that he has to review. Right now, he gets 2 hours a week to review them. He's got a November trial date. It's not going to happen, Judge. It's taken me almost 7 months to get through the bulk of what was happening with Trooper Proctor. So I'm here again, Judge, saying that this man should not be treated any differently than any other witness in any other case. Why are we protecting him? Why is the Commonwealth protecting him? Why is anyone protecting him?
Praise be.
The public should get to know exactly who he is and what he's done. They do that with any witness. If it's a regular witness who appears before any judiciary body and they've done something wrong, they have criminal records that they plaster all over the front page of papers. Nothing like that is private. And so why are we considering this private in this case, Judge? And that's really the issue that I have. And I've also, we're not arguing today, Judge, but I've filed motions in both Mr. King and Mr. Johnson's case for materials regarding Mr. Proctor's hiring, Mr. Proctor's application, Mr. Proctor's, whoever reviewed that application, any of the exhibits to that application, and then any and all of his training, because I think his lawyer said it best. Our point is that he's biased. It's certainly against Black and brown individuals. I think Ms. Reed has a different issue, and I'm not disputing that he's biased against women as well. But in this case, Judge, our position is that it's not a separate entity. In other words, when we did the Ellis case, and we knew the police officers at Ellis were committing crimes, in the beginning, when the first lawyers filed that motion for a new trial, we couldn't connect the crimes to the actual the conviction in Ellis. And it took us 18 years to be able to do that. We were able to finally connect it. This is completely different. This isn't like that. It's not a separate entity. It's who this man is. He's a racist, really a racist person from the beginning. Some of the things that he says, Judge, which I know you've heard through the grapevine, but some of the things that he says, like he'll say things like, "It's kill an N-word in Canton Day." Everybody get there. Like,
I get you.
It's kill an N-word day in Canton today. She's telling us everything. Wow. She had to hold her tongue, but she let us know that. It's kill an N-word in Canton today. She says these messages have been going on in Proctor's phone from 2014 to 2022. And she thinks that everyone has the right to know who Michael Proctor is. Why are you protecting him? Well, she didn't say you, Judge Doolin. Why is everyone protecting this man? He should have no more protection than anybody else. Let's hear that again, because she's on a rant. I didn't want to interrupt it, but that, my dears, was the crowning blow. Just one of the things, oh, there's my freeze game on point again. One of the things found in his phone, in addition to all of the nudes, praise be, under her eye, Rosemary Scapiccio is telling us everything. She's 11 out of 10. Listen to this. We need to know who this man is. The public deserves to know. Let's hear that again.
Individuals, I think Ms. Reed has a different issue, and I'm not disputing that he's biased against women as well. But in this case, Judge, our position is that it's not a separate entity. In other words, when we did the Ellis case, and we knew the police officers at Ellis were committing crimes, in the beginning, when the first lawyers filed that motion for a new trial, we couldn't connect the crimes to the actual the conviction in Ellis. And it took us 18 years to be able to do that. We were able to finally connect it. This is completely different. This isn't like that. It's not a separate entity. It's who this man is. He's a racist, really a racist person from the beginning. Some of the things that he says, Judge, which I know you've heard through the grapevine, but some of the things that he says, like he'll say things like, "It's kill an N-word in Canton Day." Everybody get there. Like,
I get
this is
your
what we're
point.
dealing with, Judge.
I get your
So
point.
what are we protecting? That's what I can't figure out. What are we protecting here?
Okay.
Why isn't he subject to the same type of scrutiny that every other witness and every other case is subject to? And I'm saying it specifically for Mr. Johnson, who's in custody, who doesn't have access to his materials, who can't be ready for a November trial date unless we do something different, Judge. And in this case, the difference that I want the court to consider is to be able to give him all of these materials in paper form, in a single cell, so he can review them and be ready for his November trial, Judge. That's what I'm asking.
Thanks very much. Attorney Krowski.
Judge, thank you. On behalf of Mr. De Los Santos,
She also said he was passing around these messages like he was saying, please pass the butter. We have a smooth as butter emoji that we created for Alan Jackson. Motion granted to use it here. Please pass the butter. That's the way he was saying these things. Here's Joe Krowski, who has been on court TV on the side of the Commonwealth and against Karen Reed. It'll be interesting to see if he now takes a different position against Michael Proctor. I can't wait for this. And look at this court officer right here. He's enjoying it. He's blocking our view of Mr. and Mrs. Reed. We can still see Karen. She still looks beautiful. Look at his face. He's disgusted too. He's like, you give us a bad name. Please pass the butter.
Krowski.
Judge, thank you. On behalf of Mr. De Los Santos, to the extent we have any standing whatsoever in the civil matter, which seems to be what we're addressing, Mr. De Los Santos does not object to the free flow of information, any and all relevant information being turned over to Ms. Reed's counsel. As a matter of fact, I think that Mr. De Los Santos inevitably will benefit from the more information that is shared related to Trooper Proctor in the contents of his cell phone. I can echo the comments of Attorney Scapiccio. We do have access to 44,000 pages. I will tell you, it is breathtaking, upsetting, and unnerving. We agreed to a protective order at the beginning of this case just because we wanted to get the case moving along. I can tell you that I anticipate within the next 3 to 4 months, once we've had a chance to go through all of this documentation, to get total and absolute relief from the protective order in the criminal case. I will say, we are mindful there are some innocent third parties that have been captured in all of the malfeasance in the cell phone. We'll do whatever we can and work with the court and Commonwealth to make sure that we don't bring them into this. We don't re-victimize them. We don't harass them. But the information in them is all germane to how an investigation in my client's case, Mr. De Los Santos's, was conducted. So we have absolutely unequivocally no objection to what is sought by Ms. Reed's attorney. I just think it's not my case, a civil suit, but I think there was counsel misspoke. Ms. Proctor has not been sued for defamation. But that's our position, and I have talked to Mr. De Los Santos about this.
Okay.
Thank you.
Thank you.
Thank you.
Did Joe Krowski just flip on national TV, on worldwide TV? Did he just flip? I know somebody is going to be able to pull all the clips of his from Court TV where he talked about nothing was wrong with this investigation at all. And now he wants everything too. Was he Colin's lawyer at one point, Colin Alberts? This is interesting. Flipping in real time.
No objection. No objection.
Thank you. Whoever wants to argue for the Commonwealth. Attorney Bailey.
So my understanding of the purpose of today's hearing is to deal with the civil matter.
It is.
If counsel for either of the defendants wants to make a written motion to alter the terms of the protective order, they are free to do that at any time, and we are happy to engage in conversation outside of filing of a written motion. The Commonwealth, because there is significant interest in what's happening here today, I would like to make it clear that the Commonwealth has no interest in protecting former Trooper Proctor's statements that are contained on these phones. And we have engaged in providing expedient production of discovery to these defendants and all other defendants who are impacted.
They're not protecting Proctor anymore either. That's the Norfolk County DA's office. She's ADA Lisa Beatty, and they have zero interest in protecting Proctor either. Everyone has turned on Proctor. He's the fall guy. And boy, is he falling. Or the judge could just order it from the bench. Really? Do you think Doolin's going to want to deal with a written motion? No, he's just going to say, I'm going to amend the protective order. Maybe. Let's see.
And so I want to make it clear that the reason that we had to seek and obtain a protective order to begin with was in part because this court directed us to do so when you directed us to obtain this material. So we follow court orders. That's number one. Number two, as some people have alluded to, there is material contained within the thread of these text chats that does impact significantly innocent and unknowing persons. So the only way to provide the true substance of these text threads was to provide it in its entirety with a protective order. That's what we did, and I think that defense counsel would agree that that was the appropriate way to provide it at that time. If we need to make alterations, we certainly can do that. In terms of today, we have continued to treat all entities that have sought this information equitably and fairly. If there is a request for this information, and in this case, it was a subpoena that we responded to, the subpoena came from a specific civil case. We have a confidentiality agreement that relates to this material that Ms. Reed and her counsel agreed to. Then we sought alteration, and this was contemplated in the confidentiality agreement from this court to produce this material for that lawsuit. We did that. That is what Ms. Reed agreed to. She now wants to change that, and then there would not be any sort of litigation or any sort of court proceeding overseeing the next production. And that is the fundamental difference. In a couple of weeks, if there's a lawsuit that's filed, there can be another subpoena. We can then entreat all parties, whoever the parties are, to whatever lawsuit, identically produce discovery in an orderly format to those parties, assuming that that's what's appropriate at that point in time. It is completely unclear to us why we need to deviate from that protocol. And I, again, want to reiterate to the court, we are treating multiple parties in the same way. It is not just Ms. Reed, the town of Canton, Post. There are a number of different entities that have reached out to us asking for this material that we have said, we cannot just give it to you. So it doesn't matter who the entity is. We are asking that there be a court proceeding overseeing this material.
Okay, thanks very much. I'll just give you a minute. Go right ahead.
Thank you. First of all, there is a court proceeding overseeing this materials. It's your honor. It's why we're here, why I've now been here twice as the civil attorney. So again, all I'm asking is you add one case to what you've already ordered. we would have to comply with the remainder of your order in that case.
Do you intend to file that suit within the next month?
Yes.
When does the presentment period end?
So the state police has actually rejected the presentment, so we could file that, but the town of Canton's period elapses roughly mid-May. So that's right around the time.
Okay. All right.
Just briefly, the town of Canton's allegations were brought up about leaking. Miss Reed hasn't leaked anything. There's no evidence of Miss Reed leaking anything. First of all, the document that the town of Canton referred to, Sergeant Good's dismissal notice, was produced also by the town of Canton to a third party, not Miss Reed, not my office, in response to a public records request. The media reporting on that letter that Mr. Proctor's counsel's attorney referring to explicitly says this was obtained by, and it gives the Twitter handle of the party that got that document through public records request.
Queen Corey Hopkins got it from a public record request. It wasn't leaked by anyone. Don't let them hoodwink you, Your Honor. And look at Proctor's attorney. He's like, what am I doing? Why do I have a baby shark hairdo? And why did I agree to take this guy's money? Because I can't in good faith even stand up for anything Michael Proctor did. And here is Michael Proctor in the upper corner of your screen during his interview where he said he wouldn't have done anything differently in this investigation.
It didn't come from Miss Reed. So that's just not true. Town of Canton's not here to argue it, but it's not accurate. Also, there was nothing preventing that from becoming public. If for some reason it had come from our office, it's allowed to be public. There's no restriction. So this idea that leaking, we heard it in the oppositions to this case, that things that are filed publicly will unquestionably be leaked. If they're filed publicly, they don't need to be leaked. They're filed publicly. And we're already allowed to do that in the O'Keefe case. We are just asking to be able to do that elsewhere. And finally, as to relevance, Mr. DeGangi referred to the claims. He referred to what statute it's under, who's a party, what we allege. We haven't filed the complaint yet. He doesn't know what we're going to allege. The point is we have these documents. They're relevant to the claim that we're going to bring. And when Mr. Proctor and his counsel read our complaint, they'll see why they are so relevant. But this is not a matter we should be talking about relevance in a criminal session where we're just talking about the confidentiality and protecting third parties, which we all want to do.
Okay. Thank you, Walt.
Your
I'll
Honor,
take it
may
under
I-
advisement.
may I
I'll
have-
give you
10 seconds.
yeah, go ahead.
If
It's like FML.
you allow Ms. Reed's motion, I would ask that the court also issue an order allowing the DA's office to produce these 44,000 pages of documents. I've never seen them. And that's in my motion.
Okay.
I don't know what that means, to be quite honest.
All right.
I'm not going to be able to comply with 44,000 pages. So I just want to, that's not the way we produce materials. So.
Okay. I'll take it under
And
advisement.
Judge, I can just
Yeah.
correct the record. Carmel said we hadn't filed a motion on record in Mr. King's case, and I believe Mr. Johnson's case is our motion in response to the Commonwealth's motion to provide law enforcement bodies information. This is the post stuff. And or to vacate or modify the protective order. It's already on file, Judge. That's all I have to say.
And we
Okay.
litigated that, we changed the order, we litigated before Judge Krupp, and that is the modification that is presently in case, in point.
Nice to see you all. Have a good
Thank you.
afternoon.
Thank you, Your Honor.
Taken under advisement. Mr. King's case is next on June 18th at 3:30. As to De Los Santos et al., that's on May 8th at 2 p.m.
Okay, all right, thank you.
Thank you, Madam
Yeah.
Clerk.
Let's make it the dates.
Just so you
Hold
know,
on.
May 8th, I may be on trial, so Mr. Crosby may be standing.
Okay.
That is next.
Have a good afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Taken under advisement. Mr. King's case is next on June 18th at 3:30. As to De Los Santos et al., that's on May 8th at 2 p.m.
Okay, all right, thank you.
Thank you, Madam
Yeah.
Clerk.
It's taking it under advisement.
I may be on trial, so Mr. Crosby may be standing.
Okay. I think Judge Farwell, is that in this session, Attorney Scott Piccio?
I don't think that it is, Judge. No, I think it's in.
It'll be with Judge Sullivan.
Oh, Judge Sullivan. Yeah.
I just want to let the court know I'm
Thanks.
starting the trial.
All right. Good.
Thank you.
Bye.
You are muted.
Lally ran out of there. Oh, no, he's still there. He's sitting underneath the window taking notes. Karen Reed and her parents filing out. I don't see
Attorney Krosky,
Proctor.
Can you stand by for Mr. Andre?
I sure can.
I mean, stop this here. Wow, we didn't know that was going to be so fiery today, did we? Well, if you're just joining, welcome. You missed a great hearing for the Karen Reed. Karen Reed is trying to get permission to use Proctor's phone dump that was provided to the defendants in the Myles King case and companion cases in Norfolk Superior Criminal Court. She's trying to get permission to use parts of the phone extraction in the complaint that she intends to file civilly against the town of Canton and the Massachusetts State Police. And so in order to do that, I think the Commonwealth was fighting them, and we've been over so many motions, it's hard for me to keep them straight. But in order to do that, they need the protective order that was in effect in the Myles King case to be amended to include Karen Reed and her, what is now a federal case. But Aaron Rosenberg, her attorney, said, we can't sue the town of Canton and the Massachusetts State Police in federal court, so it's going to have to be a separate lawsuit. And he does say that they intend to file that by mid-May because the Massachusetts State Police rejected their notice of presentment. In New York, we call it a notice of claim, and that gives the municipality a certain amount of time to either settle your case or reject it. And town of Canton, I think, Massachusetts State Police has already rejected it. Town of Canton, the time period would expire mid-May, so he intends to file that lawsuit by mid-May. But we heard Rosemary Scapicchio screaming into the universe that this man is a racist and misogynist pig, basically. But, Your Honor, he said such things in his phone to other troopers that were like he was saying, just please pass the butter. He actually said, and I quote, and they tried to shut her up real quick, it is kill an N day. It is kill an N word in Canton Day today. Come on down. She referenced the Ellis case, which many of you have pointed out to me, I think it was on Netflix, Trial 4. I haven't had a chance to watch it yet, but she was the attorney for, I think, Sean Ellis. Don't quote me on that. She's saying the protective order is ridiculous, Rosemary Scapicchio, because my client, Mr. Johnson, is in jail. He's only allowed 2 hours a week to review over 44,000 pages in Michael Proctor's phone. Aaron Rosenberg argued for Karen Reed. We learned also, please. Let me just check my notes. That there were several nudes. Aaron Rosenberg didn't say nudes, but Michael Proctor's attorney did. Many, many nudes of women exchanged between Sean Good and Michael Proctor. Rosemary Scapicchio told us that this behavior, this racist, misogynistic, anti-Semitic behavior, goes all the way back from 2014, I think, to 2022 in this phone dump. So this is not new. At all. There are also messages between Good and Proctor that Aaron Rosenberg says led to the suspension of Sergeant Sean Good. We have not heard any results, or we have not seen any internal investigation report or anything. So we don't know why Sean Good was abruptly suspended with pay, 2014 and 2022. Aaron Rosenberg also said that we can use this stuff if we want to, Judge. It's not up to the Commonwealth to tell us what we can and can't use, because I think he said we already have it. He was just looking for permission to use it in their complaint. And we know there are images of women in there. We're going to be cognizant of that. He also said that conveniently, after the extraction that was permitted by, was it Judge Doolin? In August of 2025, after the extraction was done by the Commonwealth, in which Proctor's attorneys argued, well, he reset his phone in February 2024 to everything to auto delete every 30 days. So you're really not going to get anything from this phone except maybe the last 30 days, but here you go, we'll give it to you. And originally, I think it was Judge Doolin, Judge Krupp, who said you can only use or extract things from the date of Myles King's crime to present. But then I think it was Judge Doolin who said, nah, I'm taking away that restriction on dates, and you can just have the whole phone extraction. But Proctor's attorneys weren't worried because they thought they were only going to get 30 days worth of material. We know that when they downloaded it, they got something like his entire phone extraction going all the way back to 2011 or 2012 to the present. So Aaron Rosenberg pointed out that conveniently, after Michael Proctor handed his phone over to the Commonwealth in August of 2025, and from the time they got it back until the time that Rosenberg requested it in the civil case, he conveniently lost his phone again, effing again, conveniently, said Aaron Rosenberg. Doolin's order, there was a February of 2026 order from Judge Doolin in the Reed case that they referred to. I probably have it somewhere, but off the top of my head, I don't know exactly what it says. Proctor's attorney was there too, and his name is, well, please, Tom DeGangi. Tom DeGangi was the attorney for Michael Proctor today, and I think he's representing him also as a defendant in the case of Karen Reed versus everybody. He got up with his baby shark hairdo and lots of hair product and said, there's no way in hell, Judge, that they're going to succeed on he actually said they're not going to sue my client. He's not a part, but he already has a party. So I'm very confused about that. That there's no way that any of this could be used in a failure to not supervise. He said failure and employer, a lawsuit against his employer, the Massachusetts State Police, for failure to negligent hiring and negligent, I say supervision, but he didn't ever say supervision. That's what I was screaming in the background. Negligent hiring and retention, etc. And then he admitted that there were nude photos in Proctor's phone, but he seemed to be very, very concerned about, those ladies' privacies. And he did point out very vehemently that in all of these years, Proctor's such a great guy. He was never disciplined. He was keeping drug dealers away from the schools where our children go. He was keeping murderers off the streets, and he was keeping rapists away from children. Oh, right, except for Matthew FARWELL. Yeah. And then the whole thing was wild. Lally was sitting underneath the window. We thought maybe he was going to take the stand again today. Again. DeGangi said, Proctor's attorney said, Michael Proctor has been investigated by the Norfolk County DA's office, the Massachusetts State Police, and a federal grand jury. And nobody found him liable for anything. Hasn't he been through enough? Yes. Hasn't he been through enough? And we were all like, the federal grand jury investigated Proctor. And then he said that, a special prosecutor let that slip on March 4th of 2025. Well, at that time, Hank Brennan was the special prosecutor for Karen Reed, the very expensive one. And he did say something like, we have information, or we know for a fact that the federal grand jury, that the federal investigation is closed. Nobody ever said that target was the Proctor. Wasn't everybody screaming that Proctor didn't get a target letter? None of the Haas defendants got a target letter. And so nobody was a target of this investigation. But Proctor's attorney just said the Norfolk DA's office investigated Proctor. So maybe somebody wants to FOIA request that. That's news to me. Did anybody know that the Norfolk DA's office investigated Proctor? Because I find it hard to believe that Proctor's attorney would get up and lie. Except maybe for when he said, my client has been through enough. And that last week, the people inside the house at 34 Fairview filed a lawsuit against Mrs. Proctor, which we knew he meant Karen Reed, but he misspoke. Krowski did correct him. Rosemary Scapiccio, our spirit animal, who is the attorney for Myles King, she also represented, I think it's Sean Ellis in the Trial 4 Netflix series, said the protective order is ridiculous. My client can't review anything in jail because he's only given 2 hours a week. Michael Proctor said this stuff like he was saying, please pass the butter. And again, I'm going to say it again a little louder for those in the back. She told us something that we did not know. Not only is he misogynistic, anti-Semitic, racist, and whatever other words you want to throw in there, there is a text message in there in which Michael Proctor says, today is kill an N-word day in Canton. Come on down. Or something such as like that. Judge Doolin quickly cut her off because I think she wanted to go a little further and let us know a little bit more about what was in his phone. And then Joe Krowski got up. Joe Krowski was a frequent talking head on court TV during the Karen Read trials. He also at one point represented Colin Albert when they were trying to get discovery from Colin Albert. Joe Krowski was very anti-Karen Read when he was opining with his talking head on court TV. Today, all of a sudden, he got up and he flipped. He wants all the information too. He wants everything on Proctor's phone too. Proctor's a bad guy. Proctor bad. ADA Lisa Beatty got up and argued for the Commonwealth. She said, well, if the other defendants in this case, like Myles King and Bianca Cianocchio, Sean Johnson, if these other other defendants want this stuff, they need to make a motion. They need to write a motion because there's a lot of innocent people involved in these messages, and they shouldn't be subjected to their information getting out there. We also heard Aaron Rosenberg. Okay, who was the one who argued about Sean Good? Okay, Proctor's attorney was the one who said, when Sean Good's suspension came out, that document was quickly leaked. And so we don't think that any of this stuff should be leaked. And we know they're going to leak it. But Aaron Rosenberg quickly got up and corrected him and said, that one-page document about Sean Good was obtained pursuant to a FOIA request of someone totally unrelated to this case. And it shouldn't be private anyway. But nobody leaked it, Judge. And then Judge Doolin said, okay, everybody, I'll take it under advisement and we'll see what happens. But that was, it was nice to see Judge Doolin again. Margaret, our favorite court clerk, who absolutely knows how to pick the alternate jurors by spinning the bingo balls. Well, first she shows everyone the bingo balls with the juror numbers on it. Then she puts them in the bingo drum and then she would spin them and then she would show everyone the alternate juror numbers when she picked them out of the drum. I think it was during Harry Turk's trial. You can correct me if I'm wrong. So we will anxiously await the decision of Judge Doolin about whether or not Karen Read will be able to use things from Proctor's phone extraction and quote them in the new lawsuit that will be forthcoming within the next couple of weeks against the town of Canton and the Massachusetts State Police. It will be filed in state court because the federal court will not have jurisdiction over those two municipalities. And we will see what happens. This is a great question. Anne says, why is Myles King? No, I think it's Sean Johnson. She represents him too. I think it's Sean, his first name. She said Johnson is in jail and he can only have 2 hours a week to review his evidence. Sometimes there are restrictions put on prisoners about how long they're allowed to look at their case files. I remember in the Rex Heuermann case, the Long Island serial killer case, he was given something like 4 hours a day to come into the conference room and do it. And so I don't know what the rules are in the Norfolk County Pokey, but thank you very much. Yes, and Julie is backing me up. She says Myles King's out on bail. Rosemary was referring to Sean Johnson. Thank you so much. Yes, there are many co-defendants that are involved in there. I think there are 3 defendants in the Myles King case. They're all co-defendants. And then there are some other companion cases in which Proctor was the lead investigator. Is that true, Emily? I don't want to put that up if it's not true. Can anybody vet this about Ken Mello? Having an arraignment on June 3rd. Is that real information? I don't know anything. Oh, Jess just posted it. Okay, we're gonna need to learn more stuff on this. Hang on a second. We fall into rabbit holes here. That's what we do. So please hold one moment while we look into that. Somebody also said that there was a denial. Proctor was denied in federal court. So I'm gonna look at the PACER docket on that so we can kind of cover all of this stuff at the same time. So before we move on to all of the other topics that we had scheduled for today that now we might not get to. So bear with me for a moment while I look for that. All right. This was just posted 41 minutes ago in the Fall River Reporter as tweeted by Jessica Machado. If you do engage on Twitter, her handle on Twitter is Jess Machado Show. Let's pull up an article involving Ken Mello, the former special prosecutor. He really kind of still is in the Aiden Carney cases, right? I mean, was he removed from all the cases? Hold on, please, 1 second. This is involving Ken Mello. Let's see what this is all about. You can't make it up, folks. You just can't make it up. And when we find out stuff in real time, this is called real-time rabbit holing. Maybe we need a shirt for that. All right, let's go here. I needed proof of a life on Mello for a long time. I can't. Michael Proctor freaks me out. Bye-bye. Okay, here we go. Call me Alice. This is 41 minutes ago on 46 minutes ago. I'm sorry, on the Fall River Reporter. Fall River lawyer facing charge after alleged incident at Charlton Memorial Hospital. There's a picture of the hospital. A Fall River lawyer is facing a charge after an alleged incident that took place at a local hospital. According to a police narrative, on March 11th, a special state police officer was made aware that an unidentified party had threatened to stab unidentified staff in the emergency department on March 7th at approximately 11:30 at Charlton Memorial Hospital. The officer then proceeded to the emergency department and spoke to the charge nurse. I wonder if she's anything like Nurse Dana on the pit. Spoke to the charge nurse who was working during the incident. She stated that the patient, 69-year-old Kenneth Mello, oh boy, this is like an episode of The Pit, had disrupted the emergency room, loudly objecting to his treatment and yelling that he should not be crossed because he was a lawyer. The officer stated that he acknowledged that Mello was indeed a lawyer. Oh my God, he's unhinged. And Mello is the same lawyer who called the Canton PD when he was driving by Chris Albert's pizza shop, and there were people outside with signs, and he was instructing in real time the Canton police on what they could charge these people with. This is like a real episode of The Pit where somebody goes berserk in chairs because they've been sitting in chairs for too long. If you know, you know. I'm going to read that again. The officer then proceeded to the emergency department and spoke to the charge nurse who was working during the incident. She stated that the patient, 69-year-old Ken Mello, had disrupted the emergency room, loudly objecting to his treatment and yelling that he should not be crossed because he was a lawyer. Don't you know who I am? I am a special prosecutor against Turtle Boy. The officer stated that he acknowledged that Mello was indeed a lawyer. Mello was apparently unhappy with the nurse, stating at one point that she should be nothing more than a medical technician. The nurse told the officer that when Mello was being discharged, he demanded that the stretcher be wheeled directly to his vehicle. She is unable to do that per policy and offered a pillow on the wheelchair for his pain, stating it would only be 5 minutes in transit. Mello then allegedly told the nurse, "How about I take a knife and stab you for 5 minutes?" What? What? How about I take a knife and stab you for 5 minutes? I mean, he probably meant, and I'm not defending him here, that I'm going to have a stabbing pain for 5 minutes in my back, so I want you to wheel me in the stretcher. But he actually said to the nurse, how about I take a knife and stab you for 5 minutes? Imagine if he said that to Nurse Dana. Does anybody watch The Pit, or am I talking into like nobody has any idea about my references? Wow. Hold, please. On Wednesday, a criminal complaint was issued against Mello on the charge of threat to commit a crime. That was yesterday. He has an arraignment scheduled for June 3rd. Okay, we'll be there. Ken Mello's arraignment on June 3rd. Why are they taking so long to arraign him? Where is Charlton? Is this Bristol County? It's the Fall River Reporter, so I was thinking maybe it's Bristol County. Am I getting my counties right? Wow. Thank you. And Dana is amazing. We love Nurse Dana in my house. We sure do. Don't you know who I am? I'm Ken Mello. How about I take a knife and stab you for 5 minutes? I'm a lawyer. Don't you know who I am? I mean, really, Massachusetts just is the gift that keeps on giving. You cannot make this stuff up. Stacey says, Turtle Boy tweeted, you'll never guess who got arrested for threatening to stab a healthcare worker. Story coming soon. Stay tuned. Well, sorry to spoil it for you, but it was Ken Mello. I have no idea why he was there. They're not going to say because, you know, HIPAA. But apparently, he was in the emergency room and then he was discharged. Charlton is in Worcester County. Okay, he's from Fall River, and so that's why they say a Fall River man. All right, thanks for clearing that up, fancy fact finder, and I think the Goodmans did too. All right, so Worcester. I think that's local for Aiden, so you know he can certainly show up at the Ken Mello arraignment, and won't that be interesting? Yeah, here's where I got confused. It said a Fall River lawyer. So I assumed that because he lives in Fall River, that he would go to the local hospital. But you guys are telling me that Charlton is in Worcester. You're saying it's not in Worcester. I don't know. We'll figure it out. Charlton Memorial is in Fall River, says Kay Willis. She's a realtor, so she might know. All right. So everyone's saying, all right, see, this is why I don't highlight comments sometimes because it's wrong. I was right. Okay, there's something I like saying more than I told you so. So I'm going to go back to my original guess that it was in Fall River and Bristol. Thank you very much, Kay Willis. She's a realtor. I'm glad we straightened that out. Okay, here's where we got confused. The town of Charlton is in Worcester County. The hospital is in Fall River. Thank you, Mermaid. Okay. Can we settle it now? Okay. Thank you. Thank you. I understand now. I understand. Thank you so much. All right. Well, that's interesting. That was a good little side quest that we just went on. Let me just check the read docket real quick in federal court to see if what somebody told me was actually true, that there is a decision on the Proctor motion in federal court. Hold please while I do that. Thank you so much. Talk amongst yourselves for a minute. Because if it's something involving Proctor, we might as well stay on this subject for a moment. Okay, Massachusetts District Court. Well, for some reason, the docket in that case won't load. Hold on. Oh, wait, here it is. Yep, got it. This is a it's a ruling. It's a decision. It's a 3-page decision by Judge Casper. It's not really 3. It's like a page and a half. Would you like to see it? I mean, sure, we're here. Why not, right? It was the same lawyer, Mr. DeGangi, who made that motion in federal court. And hot off the press. Actually, it says it was filed. How does it say it was filed on April 10th? Hold on. Maybe the motion was filed on April 10th? In any event, here we go. Gonna have to redo my whole thumbnail. Whatevs. All right, this is Defendant Michael Proctor's motion to conduct limited discovery. No, that's the motion. Okay, I clicked on the wrong thing. That's why. Hold, please. That's the motion. I didn't want the motion. I wanted the order. The order on the motion. Well, it just says the court denies the motion. There is no clickable written decision, but it just says, I'll show you the docket instead. (4/23/26). That's today. Chief Judge Denise Casper electronic order regarding filing 66, which was the motion by Proctor to conduct limited discovery to third parties prior to the court's establishment of Rule 16.1 and Rule 26 conference, having considered the motion of defendant Mr. Proctor to conduct limited discovery prior to the scheduling conference in this matter. Docket number 66 and 67 and the plaintiff's opposition, docket 68, the court denies the motion. All right, so that was denied. Sorry, Proctor. Sorry, Proctor. No discovery for you. Nurse Jackie would have knocked him out, said Dreamer. Oh, my goodness. Yeah, remember Proctor made a motion. He wanted to force Karen Reed to turn over his phone extraction because he doesn't have it and he doesn't have access to it because he doesn't work for Massachusetts State Police anymore, so he can't get it. And I said, well, don't his attorneys have it? Why can't they give it to him? And then the motion was just denied. So there's that. Let's go to the chat. I'm sure you guys have a lot to say. A lot to say. Brass, thanks for your 10. As a lifelong Massachusetts resident at 52 years old, not believing the Commonwealth version of events when you know they handled how they handled Sandra Birchmore. I had doubts about Karen Reed's charges. Then Turtle Boy confirmed them. Thank you for your 10. Christine Mitchell says Melanie Proctor has been denied Karen's materials. Thank you. I just looked it up because of your super chat. I just found out that it was denied. No written order, but oh, bad. Too bad. So sad. Thanks, Christine. Gigi said, I'm still sick. I miss you all. Have a great Thursday. Thank you, Gigi, for your super chat and for your gifting memberships. Oh, I turned off the jewels, that jewels thing, because I didn't know what they were. And I couldn't properly thank you because it didn't come up on StreamYard. So hopefully you don't get sucked into that again. I don't know what that was all about. It was weird. It's like, we're not 12. We don't need these things popping up on the screen. It was kind of weird. Devi says, Adam Deitch collected 2 times the required signature amounts to get on the ballot. He has the support of Sandra Birchmore's family. Norfolk County, it's up to us. Thanks, Debbie, for your 5. And BB says, did you see or hear Boozy Beauty's latest find? Greg Connor claimed he wasn't involved in the Reed case. He doesn't know anything. Then why were you copied on over 4,000 emails? XOXO. Thanks, Aunt BB, so much for your 10. I think you told us everything that we need to know. But check out Boozy Beauty on Twitter if you choose to engage over there. Casey says Lally is dreaming of a Costanza-style desk at the courthouse, possibly with a Fusilli Brennan. Well done. Seinfeld references are always welcome. Boy, Lally was over there pretending not to pay attention and taking notes and pretending like he had another matter in that courtroom, but did he? I don't know. Beth Ellen says, that's BS. If I get company email on my private phone, my company has every right to access my phone data. They make that clear in the handbook. Yeah, we all know. We all know that. I mean, I don't know why his attorney didn't know that, but if you use if you're doing police business on your personal cell phone, it makes it discoverable. We know that. Thank you, Beth Ellen, for your 5. The Watcher said, let's get Lally back on the stand. I wish it was that easy because that was a great day. Nick Indy, you mean Proctor never got caught. That's why he was not disciplined, right? But during our deep dive, I think, of the new lawsuit filed by the Haas defendants against Aiden and Karen, or maybe it was a different day because now I don't remember. We did listen to some audio from the internal affairs investigation of, was it of Proctor? Yeah, and it was Tully. And he said that they had to sign an NDA with the feds because Michael Proctor testified in front of the grand jury, the federal grand jury, February of 2024. That's when they became aware of his inappropriate text messages. And in order to see them, I think it was Laura McLaughlin who had them sign an NDA, and they weren't allowed to talk about it. So they couldn't use that as a reason to discipline Proctor because they were subjected to an NDA. He did get caught. They knew because they were on those group text messages, Tully, Buchanan, Fanning, his supervisors, and sometimes they liked them and sometimes they hearted them. But according to Buchanan, when he thumbs up a message, it just means he acknowledged it. Remember? Thanks for your 5. Casey Paralegal says, listening to you helps me. Your voice is like a second mom. Had a few bad days and your voice is so comforting. Thank you. Oh, I'm sorry. I hope your days are getting better. Casey Paralegal, thanks for your 5. Helen Keller's diary says this means they're going to try and cause a large disruption or distraction soon. Don't fall for it, guys. Stay focused. Oh, I know the trolls were coming for me last night. They have scrubbed through, I think, all of my hundreds of hours of coverage on the Karen Reed case to try and find me defaming some of the people in that lawsuit, threatening that I'm going to be sued and everything else. And I mean, the highlight reel that they came up with, I forget who posted it, but you guys sent it to me, was like a 3-minute highlight reel. And I'm like waiting for the defamation. I'm like, okay, it's like, okay, that's really the best that you could find when you're accusing a lawyer who's reading court documents and watching trials and interpreting, the testimony, the data, the decisions. That's the best that you could do. Yeah, they are. They're gonna cause a large disruption or distraction soon. And it's so funny how they hate me so much and they watch every single one of my shows, every single one of them. They really went deep into the archives too, because there was like some clips of me from like trial 1. I mean, it was crazy. But if you've seen it, you know exactly what I'm talking about. Where's the defamation? Okay. But that's the kind of distraction that they're looking for. Or that, when it ramps up like that either what I'm saying is very influential and that people are going to listen to me because I'm making way too much sense, or they have nothing else to talk about. Really, their lives are that empty. It's sad, really, really sad. Zoe says, where are the charges from the Commonwealth against Proctor for disseminating nudes electronically? If they're not protecting him, why aren't they charging him? That's a great question, Zoe. Remember one of the shows that I did, I found a couple of cases from other states, federal cases, where there were cops serving, 2 to 4 years in federal prison for doing the exact same thing, for distributing nudes of crime victims. Oh, please. In fact, I remember the case now. There was one guy who stopped a woman in a traffic stop, took her phone back to his cruiser because her insurance card and her registration were on it. And then he found some nudes in her phone, and then he used them. He sent them to himself. I mean, the whole thing was wild. Pro tip, and here's your free advice of the day. Keep physical copies or photocopies of your registration and your insurance card in your glove box. Do not hand a police officer your phone and show him a copy of your insurance card. Keep the physical copies in your glove boxes. Make sure your kids do the same. You're welcome. Tony says, Beatty is again kicking it down the road, I think you meant to say. She's ridiculous. Thank you, Tony, for your 5. Pimabo is here. Says, we know Lisa Beatty. Oops. We know Lisa Beatty from where? Marcy emails. She's also been in court on a lot of other cases in Norfolk County. I don't remember if she was second chairing on the Brian Walsh trial. Maybe you guys remember, but she's around a lot. She's been on this case for a long time, the Myles King case. And other places. If Mastad is here, he'll remember. Tammy Love says, I don't know what that says. TUCFCCCDDD. I don't know, Tammy Love, but thanks for being here for 2 months. Thanks, Emily, for throwing us into this rabbit hole. In case you missed it, rewind a little bit. Ken Mello threatened to stab a nurse at a local hospital back in March 11th and has an arraignment scheduled for June 3rd. It's going to be in Bristol County. Thank you, old swamp witch, for loving all I do and for being here for 9 months. And Deshai says, as a Black woman, I'm disgusted. Lock Proctor up. Thank you. I'm very sorry. I can't apologize for him. The guy's pond scum. He's lower than the low. But hasn't he been through enough? His lawyer actually said with a straight face in open court to Judge Doolin, hasn't Proctor been through enough? Wow. Toby's mama says it's in Bristol County in Fall River. Thank you very much for your 5. Cupcakes for Justice says Turtle Boy to attend his attorney hearing, film at 11. Thank you. Helena says Fall River Man is the new Florida man. All the goons and normal moms in the Karen Reed Turtle Boy saga seem to think they're celebrities. Sorry, dudes. Well, thanks, Helena, for being here for 10 months. Thank you, Mrs. Bouquet, for your super sticker from across the pond. YouTube Turns says only 1/3 of the chat has hit the like button. Please hit the like button now. In the words of Proctor, nope. We have a nope emoji for that. Let me see some nope emojis in the chat. Nope. Thank you very much. YouTube Turns. And Brass says, Chapter 271, Section 51 took effect on 11/2/2022. Anything prior to that can't be charged. This is also known as Amanda's Law. Okay, I'll take a look. But that seems to be a Massachusetts local statute, but there are federal statutes against it as well. That many of these other police officers, if you're talking about the dissemination of the nudes, I don't have time to look it up right now. But if that's what you're referring to, there are federal statutes against it as well, and those are the cases I found in other states. They were all charged federally, right? Go Buffs! Oh, please. I know that David was supposed to have a preliminary hearing today, but I don't think it was televised. Was it televised? Because that's the next thing on the docket here that I have pulled up for you. And so we've already been through Farwell. I can X that out. You emailed was it televised? Oh, please. We had a last minute addition to the docket, and that was Karen Reed's hearing. Oh, please. I don't have anything from you, Emily. Fanbase at mlittlelaw.com. Oh, wait, here it is. Okay. All right. Got it, Emily. Thank you. Today was supposed to be the preliminary hearing on David, singer David, author of Romantic Homicide, for the murder of Celeste Rivas. But it seems that has been put over until May 1st, the preliminary hearing. Seems like the prosecutor said they found a significant amount of child porn on his iCloud. Great. All right. Thoughts, questions, comments, concerns on the Karen Reed hearing and Proctor, Sandra Birchmore, Matthew FARWELL. Before we move on to David, I have the criminal complaint. I do not have the autopsy report. I don't even want to read it. And I also have Aaron Spencer's new motion. So thoughts, questions, comments, concerns before we move on to or pivot to the next topic. Look at Paola coming in and gifting 10 memberships. You're awesome, girl. Thank you so much to the 10 members who were so randomly gifted by Paola, and YouTube chooses them. I don't. Thank you so very much. I love you. And BB says, I remember during one of the pretrial motions you covered in early 2024, you thought this could be bigger than Karen. Did you ever think it was going to be like this? In my opinion, we're not even close. Thanks, Mel. I am BB. I think we haven't seen I don't even think we've really scratched the surface because there's been no other arrests. There's been some fallout with regards to rehoming. Proctor got fired, some suspensions, retirements. There haven't been any arrests yet. But I still think it's way, way bigger than the Karen Reed case in general. I think it may have to do with either the Norfolk County DA's office as a whole and or the Massachusetts State Police organization as a whole. We have seen arrests in the death of Enrique Delgado Garcia, so that is also something. After the investigation into the investigation of the murder of John O'Keefe, that is when Matthew FARWELL was arrested, so that was good. So we've seen a lot. I think we're only scratching the surface right now. Thank you, Aunt BB. Andrea, tell me you weren't here without telling me you weren't here. We actually just covered this. And he's being arraigned. Ken Mello is being arraigned on June 3rd in Bristol County. So if you weren't here, which I think you weren't, because otherwise you would have heard me, we've read the entire article from the Fall River Reporter. Ken Mello threatened to stab a nurse. And so go back and watch it if you didn't see it. Thank you very much. All right. Elaine, thank you for your very generous 100. She says, oops, I'm here just catching up. Thanks for everything. Oh, Elaine, you're such a very kind and generous contributor to this channel. Appreciate you so very much. Angela says, I came to my own conclusions watching Court TV during trial 2 when I was so appalled that Yuri B was so obviously lying. Thank you, Angela, for your Venmo. Betsy, I appreciate you so much. She says, per usual, XOXO. Thank you, Betsy. Oksana, thank you very much for your very generous Venmo yesterday after the stream was over. I love you with all of my heart. And Kylie, yesterday said, I'm an hour behind, but I wanted to say thank you for deep diving through these papers with us, Mel. Love diving with you as much as Jerry Garcia loved diving. He did. Thank you, Kylie. All right. Here we go. Should be a coach says I'm going down the road feeling bad. Grateful Dead references are always welcome here too. Always. We already went over the new filing on Matthew FARWELL, Kathleen. That was the very first thing that we did. It's right at the beginning, right at the very beginning of the stream. Steve says no arrests in Delgado case. What do you mean? 4 troopers have been arrested. 3 of them have been arraigned already. The 4th one has not been arraigned. So you might have missed that. You can go back and look for it. We did that show a while ago. Zoe says at the federal level, unauthorized sharing of nude photos by first responders may be prosecuted under federal civil rights laws 18 U.S. Code sections 241 and 242 if the action violates rights to privacy. I would submit to you that it does in this case, because if what we believe Rosemary Scabicchio and Aaron Rosenberg and others were saying, these messages were between Proctor and Sean Good and led to Sean Good's suspension. Thank you. Thank you. Thank you. All right, here we go. Let's move on to the actual criminal felony complaint against D4vd, pronounced David. Did I already redact this? I think I did. Okay. Here we go. And then, all right, I don't know why I just disappeared from the screen. YouTube is glitching, StreamYard is glitching, everything is glitching. Maybe if I close some of these windows in here, hold on. Maybe that'll help, but I don't really know. All right. For those of you who do not know, we did the first show on the David case just a couple of days ago. David, D4vd is the way he spells it, is a kid. He's 21 now. But he went viral on TikTok a couple of years ago. And he also authored the anthem for a video game called Fortnite. Something like, let me see if I even have notes on this. I'm going to have to go by memory because I don't know where my notes are, but wait, maybe I do have them. Hold on one second. A young girl, 13 years old, her name is Celeste Rivas, was reported missing by her parents from Riverside, California in 2023 or 2024. Wait, I know I have the wanted post. I mean, the missing poster. Let me just say if I can pull it up. She was considered a runaway by police. But apparently there are video game streams of her playing, I don't know if it's Fortnite or something else, with this guy, David. When she was reported missing by her parents, this was in, 2024. April 5th of 2024, she was reported missing from Riverside, California, 13 years old. In 2025, I think this was just last September, David, who lives in the Hollywood Hills, he grew up in Houston. He lives in the Hollywood Hills. His Tesla had been parked on a street in the Hollywood Hills and was parked there for about a month. It was considered abandoned and it was towed to a nearby tow yard in West Hollywood, I believe. There was a horrible smell coming from inside the front trunk of his Tesla. And when it was opened up, it was discovered that inside of 2 cadaver bags was the dismembered remains of Celeste. It took a long time, took a while for them to identify her because the autopsy report has now revealed that there was something like 1 or 2 of her fingers missing, on which she had a tattoo that said David, but her body was dismembered. It was in cadaver bags, Her arms and legs were in one. Her torso was in the other. She had a tattoo on one of her fingers. Apparently, David has the matching tattoo that says, shh. Horrific. One cadaver bag, one trash bag. I'm not sure. I don't know if the real details have been released, so I'm just kind of summarizing for you. So he was finally arrested last week, about a week ago today. They said they have forensic evidence, cell phone forensic evidence against him, and other evidence against him. And allegedly, they're saying that her murder took place on April 23rd of 2025. Again, I told you, as I said, her body was not found in the Tesla until something like September. So it was 5 months. It had been decomping for 5 months, and it's horrific. Here is the felony complaint against David. He had his first court appearance. I forget what day it was, a couple of days ago. We watched it. He is being represented by the same attorney who represented Monica Sementilli. Many of you watched that trial. And it was in LA Superior Court, the same exact courtroom, same exact judge, Teresa McGonigal, who arraigned Nick Reiner. She was 14 when she died, and she turned 15 the day before her remains were found. I got some of the papers. Here's the felony complaint filed against David. He was not indicted by a grand jury. He was arrested and charged pursuant to this felony complaint, which requires probable cause, and that is why they need to have a preliminary hearing on this. Some states allow for a choice between a grand jury indictment or a felony complaint. Some states you must be indicted by a grand jury. And some states usually only use preliminary hearings. So we've seen them in all kinds of cases. I mean, we've seen it done all different ways in different states. Here we go. This is the written felony complaint against David Anthony Burke, which is his given name. March 28th of 2005 is his date of birth, aka D4vd. People of the state of California versus David. The undersigned is informed and believes that count 1, on or about April 23rd, 2025, in the county of Los Angeles, the crime of murder in violation of Penal Code Section 187A, a felony, was committed by David Anthony Burke, who did unlawfully and with malice aforethought murder Celeste R., a human being. That means malice aforethought is intent. It's the state of mind that requires intent, meaning it wasn't an accident. Notice, the above offense is a serious felony within the meaning of Penal Code Section 1192.7c and a violent felony within the meaning of Penal Code Section 667.5c. Notice, upon a felony conviction for the above offense, prison custody time is to be served in state prison based upon the above felony offense of being a serious felony defined in Penal Code Section 1192.7 and or violent felony defined in Penal Code Section 667.5c or a felony offense requiring registration as a sex offender pursuant to Penal Code 290. C within the meaning of Penal Code Section 1170H3. It is further alleged that the murder of Celeste was intentional. Celeste R is what they're calling her in these charging documents. I can't highlight it. Was intentional and was carried out by the defendants, David Anthony Burke, or the defendant, David Anthony Burke, for financial gain within the meaning of Penal Code Section 190.2A1. It is further alleged that pursuant to Penal Code Section PC 190.2A10, that Celeste R was a witness to a crime and was intentionally killed because of that fact. It is further alleged that the murder of Celeste R was committed by defendant David Anthony Burke and that the defendant intentionally killed the victim by means of lying in wait within the meaning of Penal Code Section 190.2A15. It is gruesome, the details of this case. It is further alleged that in the commission and attempted commission of the above offense, the said defendant, David Anthony Burke, personally used a deadly and dangerous weapon, to wit, sharp instrument. Said use not being an element of the above offense within the meaning of Penal Code Section 12022B1 and causing the above offense to be a serious felony within the meaning of Penal Code Section 1192.7. It was a sharp instrument. Count 2. Arna between September 7th, 2023 and September 7th of 2024 in the county of Los Angeles, the crime of continuous SA in violation of Penal Code 288, a felony, was committed by David Anthony Burke, who did unlawfully engage in 3 and more acts of substantial sexual conduct as defined in the Penal Code, and 3 and more lewd and lascivious acts as defined in the Penal Code with Celeste R., a child under the age of 14 years, while the defendant resided with and had recurring access to the child. So it seems they're saying in their felony indictment, it's not an indictment, it's a complaint, that Celeste lived with David for 1 year between September 7th, 2023 and September 7th, 2024. Which is interesting because according to the missing person poster, Celeste was last seen on April 5th of 2024 by her family in Lake Elsinore, California. Did her family know that she was living with David between the time they reported her missing in April and September? So I don't know. I don't know what her mom knew. Notice the above offense is a serious felony within the meaning of the Penal Code and a violent felony within the Penal Code. Conviction of this offense will require you to register pursuant to the Penal Code, I imagine, as a sex offender. Conviction of this offense will require the court to order you to submit to a blood test for evidence of antibodies to the probable causative agent of AIDS. Being charged with this criminal offense can result in mandatory pre-conviction HIV/AIDS testing and disclosure of the results to a victim and the chief medical officer of the jail or prison facility where you are incarcerated pursuant to the Penal Code following a probable cause hearing resulting in a court order. Notice, upon a felony conviction for the above offense, prison custody time is to be served in state prison based upon the above felony offense being a serious felony and or violent felony or a felony offense requiring registration as a sex offender pursuant to Penal Code within the meaning of Penal Code sections. These charges, if he's found guilty, he would receive life without the possibility of parole and, or I should say, or the death penalty. These charges make him death penalty eligible. California does still have the death penalty. I think it's on pause right now, but on the books, they still have it. Count 3. On or about May 5th of 2025, in the county of Los Angeles, the crime of unlawful mutilation of human remains in violation of Health and Safety Code Section 7052, a felony was committed by David Anthony Burke, who did willfully and unlawfully mutilate remains known to be human, specifically the remains of Celeste R. Let's do the math on this. They're alleging that the murder occurred on April 23rd and that she was dismembered on May 5th. A little less than 2 weeks later. Notice conviction of this offense will require the defendant to provide DNA samples and print impressions pursuant to the penal code. Willful refusal to provide the samples and impressions is a crime. People of the state of California intend to present evidence and seek jury findings regarding all applicable circumstances in aggravation pursuant to penal code and Cunningham v. California. A suspected child abuse report, SCAR, may have been generated within the meaning of the penal code involving the charges alleged in this complaint. Dissemination of a SCAR is limited by the penal code, and a court order is required for full disclosure of the contents of the SCAR. Any allegation making a defendant ineligible to serve in a state prison sentence in the county jail shall not be subject to dismissal pursuant to the penal code. And conviction of this offense prohibits you from owning, purchasing, receiving, possessing, or having under your control and custody any firearms, and will require you to complete a prohibited persons relinquishment form. So you would have to turn over your firearms, and this is signed by Joshua Byers, April 20th, 2026, under the penalty of perjury. Nathan Hockman, District Attorney, by Craig Hum, H-U-M, the deputy. No bail. He remains in lockup. I wonder if he's in the same place as Nick Reiner, unless Nick Reiner got put in a mental hospital. I'm not sure, but it was in the same exact courtroom that Nick Reiner was arraigned in. Here are the statutes. Here's what the effect of those could be. As you see, LWOP or death. LWOP or death. Ugh. Revolting. They did unseal the autopsy report. I don't even really want to read it. You're saying some other people went over it, like Baker went over it? But apparently what we're learning today, at today's appearance, the prosecutor said they found a significant amount of child pee on his iCloud. Prosecutor Beth Silverman, she also prosecuted Monica Sementilli, right? Says they got a court-authorized phone wiretap as part of the investigation. She said, I think last year. And then she said also they didn't receive anything yet from that wiretap. Any information from the wiretap. He's in the same facility as Nick Reiner. You read on the Daily Mail. Listen, the Daily Mail used to be considered a rag, but nowadays they seem to vet their information pretty well because they've been sued so many times that they're more careful about it nowadays. And they always seem to have the tea. And they vet it. Let's put up the missing person poster because always it's about the victim. Prayers up to the family of Sylvester Rivas. It's horrific. Let's see what else happened today at the hearing. This is courtesy of Megan Cuniff on X, MEGHANNCUNIFF. She apparently was in the courtroom. And it seems that Deputy District Attorney Beth Silverman said that the LAPD's Robbery Homicide Division has been trying to upload their entire file over the last month or 5 weeks, and only 30% has uploaded, and that is using multiple computers. Remind me, is this the case? Because we cover so many cases. Is this the one where they said they had 40 terabytes of discovery to turn over? 40 terabytes? I think so. Silverman also said it was David's iPhone, not his it was his iPhone, not his iCloud, that has a significant amount of child P. And under the law, child P cannot be retained without there being certain orders in place. So there's a process for that. David's lawyers provided a 1 terabyte drive that Silverman said they'll return with discovery on Monday, but Silverman said they need a drive of at least 10 terabytes in order to produce the defendant's iCloud. Right, so I think there was 40 terabytes altogether. Silverman says that the discovery includes body-worn video, DNA trace evidence, photographs from the serving of search warrants. All of those things we're going to endeavor to turn over, hopefully, by tomorrow afternoon. The prosecutor also said in court that 3 grand juries convened in David's case were convened for the purpose of investigating, not for returning an indictment. She didn't say exactly what they considered, but she said 1 grand jury convened in November, another in December, and another in February. I guess it was in front of a different judge today, not Judge McGonigal, who we love. She's always got a great blowout. She's like our favorite Hollywood judge. Judge Olmedo, another female, says she understands the defense predicament of wanting a speedy trial and needing discovery when there's a lot of it. The judge spoke directly to David about jail transport for court and said, the jail may get you up really early to be here. The bus has other stops, and it's very important you make that early morning bus. It may mean that you're in the building for a bit. Oh, boy. So David's case has been put over until the preliminary hearing is going to be May 1st. That's when they're going to show everyone their evidence for probable cause. And he's back in court next Wednesday, the 29th, to discuss how much discovery has been obtained and whether the prelim will proceed on May 1st. And that's where we stand right now. Very sad. And very gruesome. Oh, please. Thoughts, questions, comments, concerns. You want us to keep covering this David case? I just find it's wild to me. Picture of the perp. Yeah, I thought I had one here, but I got to find it again. It's wild to me that he would commit such a crime and then put the body in his Tesla and then just leave it on the street for a month before it was towed. And then he went on a world tour. Like after he murdered her, he went on a world tour. I mean, allegedly murdered her. You watch what they have so far. It did smell. That's why they looked in there, because they towed it. The parking, LA Parking, I'm not sure what the organization is. LA Parking tow guys came and towed it after a neighbor reported that the car seemed abandoned because it had been there for something like a month. In the Hollywood Hills, parked like near his house or something. He's a musician. He's a musician who went viral with a song called Romantic Homicide. Look him up on YouTube. He's got like 2.7 million subs. D4vd is the way that he spells his name. And I played a little bit of an interview the other day that I had to eventually link to the stream because it was stricken for copyrighted content. It was like a Spotify little documentary that they did of him, and he grew up in Houston. His parents seemed really nice. His father is like an electronic discovery litigation specialist at a law firm. It's crazy. All right, let me just see if I can find the picture of him. I thought I downloaded it, but I guess I didn't. Oh, please. But if you're interested in his music, one of the songs that he wrote before her murder was called Romantic Homicide. I think that's the one that went viral on TikTok. And here's, we'll just Google image search it quickly for a second. Take this down, put this up. This is his mugshot here on the left side of your screen. Here's some other pictures of him on these various articles. This was some in court the other day. We covered that hearing. They did have a camera in there. Pictures of Celeste. And I mean, go watch his videos. They're creepy. Somebody said that he was on tour. He brought a coffin on the stage. Other people say that the girl actress who's in the Romantic Homicide video looks suspiciously like Celeste. Here's a picture of him being arrested that the California Post got. Apparently he was selling merch that had blood spatter on it like this during his tour. You can't make this up. But is he the dumbest criminal in the world? Here's the headshot of him that I had the other day. That's not it. Go back. Here's the headshot from the New York Times that we looked at the other day, this one. Far cry from his mugshot, eh? Yeah. Jacqueline says the video girl is definitely a Celeste doppelganger. Cinnamon Bit says if you look at his song lyrics, he was self-snitching. Yeah, but weren't those songs written before the murder? So did he have like a fantasy of doing this and then he did it? Whitey's Ghost says he makes Nick Reiner look sane. Oh, see, I unblocked you. All you had to do was send me the correct link. Whitey's Ghost, hang please. Many of you have been deep diving into the David case for far longer than I. And so you know a lot more about it than I do, but we're here for it. Unfortunately, because it's California, we don't know if there'll be cameras in the courtroom for everything. All right, I need to move on from this because it just literally makes me actually ill. All right. Next up, before we move away from this, we are going to do a quick blurb on Jesse Butler because the court issued its decision in Oklahoma, in Payne County, on the Jesse Butler case. Are you with me? The other day, there was no cameras in the courtrooms in Oklahoma. And so the other day we had to look at, cobble together some notes from some reporters locally in Oklahoma. Jesse Butler. I don't know what you're talking about. Where can we watch Turtle Boy's hearing? What hearing? What hearing are you talking about? Turtle Boy didn't have a hearing today. We covered the Karen Reed hearing earlier from the Myles King case about Proctor's phone, but you must have missed it. Okay. Jesse Butler is the son of an Oklahoma State University football coach or prior football coach. For those of you who live in Oklahoma, you can tell the other people in the chat how big football, college football is in Oklahoma. Jesse Butler's dad was part of the OSU football program somehow. He was also part of the high school football program. Jesse Butler was 17 years old when he committed some very heinous crimes against two 16-year-old girls that he went to high school with, that he called his girlfriends. The crimes included forcible grape, forcible sodomy, choking, and in fact, he actually did videotape one of the choking incidents with regard to these two 16-year-old girls that he called his girlfriends. Jesse Butler, we watched some body cam footage the other day. Initially, Jesse Butler was going to be charged as an adult, and he was going to face up to something like 78 years in prison. But then Judge Susan Worthington got involved, and she decided to strike a deal with Jesse Butler. And she decided that a better sentence would be for him to be reclassified as a youthful offender, and he would get 1 year of counseling and community service. And after that, you know, if he goes through everything, then I imagine his record would be expunged. And the victims in that case, and the world, and Oklahoma and specifically, are absolutely outraged by this. And so one of the victims filed a motion in court arguing that their rights were violated under Marcy's law after Butler's, conviction. He didn't even have to plead guilty. He pled no contest, and then he was given this sweetheart deal. There's a civil lawsuit pending. We've been over that in the past, and allegations from the civil lawsuit against him and his parents from one of the victims allege that the school protected Jesse Butler and not her, even though she had a restraining order. This is in Stillwater, Oklahoma. And it's sick. And many of us don't believe that people like Jesse Butler can be rehabilitated, and that perhaps the next time we meet up with Jesse Butler, it's going to be inside of a courtroom, and perhaps that victim won't be so lucky as to survive. In my opinion. So under Marcy's law, one of the victims made a motion saying that our civil rights were violated. You didn't keep us posted on what was going on. We don't agree with this plea deal. Originally, they wanted to overturn the plea deal, but then they wound up withdrawing the part of their motion that wanted them to withdraw the plea deal or strike it down. But now they wanted the prosecutors to be held to account for not telling them what was going on and treating them with respect and violating their civil rights. And there was like 3 days of hearings. I don't remember if it was last week. All the days are blending together. And it was not heard by Judge Susan Worthington. But the opinion and order of the court was just published yesterday, and I have it here. So prepare to be outraged. This is with regard to Jesse Butler and the way that he was treated in Stillwater, Oklahoma court. And then after that, we will go on to Aaron Spencer. Okay, here we go. This is in the District Court of Payne County, State of Oklahoma versus Jesse Mack Butler. And this is the opinion and order of the court. Don't glitch on me. This matter comes before the court on the verified motion to enforce victims' rights filed by movants pursuant to Article 2. Stop. Section 34 of the Oklahoma Constitution and Title 21, commonly referred to as the Oklahoma Victims' Rights Act. Having considered the pleadings, the evidence presented, wait, let me see if I can do one more thing here. Hold on. Let's go here instead. Getting pretty good at this technology thing, huh? Yay me. Having considered the pleadings, the evidence presented over the course of a 3-day evidentiary hearing conducted April 13th through April 15th, and the arguments of counsel, the court enters the following opinion and order. Background and procedural history. The state of Oklahoma appeared by Assistant District Attorney Karen Dixon. Defendant appeared by and through counsel Derek Chance. Movements appeared in person by and through counsel Rachel Bussett and Brecken Wagner. Movements initially sought relief in the form of setting aside the plea agreement, reinstatement of adult charges, and/or modification of the youthful offender disposition. Prior to the commencement of evidence, movements withdrew those requests, thereby narrowing the issue before the court to whether their constitutional and statutory rights as victims were violated. I haven't done that much of a deep dive into this, and so I don't know why they withdrew their requests to set aside the plea agreement, reinstate the adult charges, and or modify the youthful offender disposition. Maybe they were advised by attorneys that they would be unsuccessful. I'm not sure exactly why, but they did withdraw those requests. And so this is the only relief that they were seeking. They were trying to, as in their words, make it better for future victims. The court finds that this matter presents an issue of first impression in Oklahoma regarding the scope and enforceability of victims' rights under the cited provisions. The burden rests upon movements to establish a violation by a preponderance of the evidence. Okay, two things. A matter of first impression means that this is the first time this issue has ever been brought in front of a judge. First time anybody's ever brought it up. The movements in this case are the victim and her parents. Only one of the victims filed. One of the victims, according to her doctor, was seconds away from death when she was being strangled by him. A preponderance of the evidence is merely more likely than not. A preponderance of the evidence is like 51% to 49%. It's like the scales of justice tipping ever so slightly to one side. Jurisdiction and authority. As a threshold matter, the state questioned whether the procedure invoked by movements is authorized by law. The court concludes that it is. Article 2, Section 34B of the Oklahoma Constitution expressly provides that a victim, the victim's attorney, or the attorney for the state upon request of the victim may assert and seek enforcement of victims' rights before any court with jurisdiction over the case, and further mandates that such court shall act promptly upon such request. The plain language of this provision imposes an affirmative duty upon the court to consider and resolve such claims. While the manner of disposition may vary depending upon the circumstances presented, including resolution upon the pleadings or argument of counsel, the court retains discretion to conduct an evidentiary hearing where factual development is necessary. Under the facts presented herein, the court finds that an evidentiary hearing was appropriate and necessary. Analysis. Movements assert two primary bases for relief. Number one, that they were not treated with fairness and dignity. And number two, that they were not adequately informed of plea negotiations, nor afforded a meaningful opportunity to confer with the state. Both Article 2, Section 34 of the Oklahoma Constitution and Title 21 provide victims the right to be informed of proceedings, including plea negotiations, and the right to confer with the attorney for the state. However, neither provision confers upon victims the authority to direct, control, or veto prosecutorial decision making. The absence of such language is significant. Had the legislature or framers of the constitutional provision intended to vest victims with decision-making authority over plea agreements, such intent would have been expressly stated. Instead, the rights afforded are participatory and informational in nature, not determinative. What they're saying is that the victims don't get to decide how much time or how much time the defendant in their case should serve. They don't need to be involved in the decision making. It's not up to them whether or not Jesse Butler was treated as a youthful offender or as an adult. They really don't have any say in the proceeding. It's all up to the district attorney. But, all we got to do is kind of keep you posted, basically. Movements contend they were not treated with fairness and dignity during the prosecution of the case. The evidentiary record reflects that representatives of the district attorney's office met with movements on multiple occasions, provided updates regarding the status of the case, discussed plea negotiations, and engaged the assistance of a victim advocate to support movements throughout the process. The state also welcomed participation by movements' retained counsel. The court acknowledges that certain communications, particularly those addressing the evidentiary strengths and weaknesses of the case prior to the filing of charges, were, by their nature, difficult and at times distressing. However, candid and direct discussion of such matters is an inherent and necessary aspect of prosecutorial evaluation and does not, without more, constitute a failure to treat victims with fairness and dignity. Yeah, here's the thing too. They were telling the girls that their evidence wasn't strong enough to prosecute him, which is another reason why victims don't come forward. The evidence presented establishes that on or about July 25th, 2025, the district attorney's office informed movements, victim's family, that it had entered into a plea agreement reducing the charges to youthful offender status. At that time, movements were advised of the material terms of the agreement, including that defendant would not be sentenced to imprisonment, but would instead be subject to supervision through the Oklahoma Office of Juvenile Affairs, with the possibility of subsequent transfer to the adult system upon noncompliance. So they're saying, hey, listen, we told you that we're making a plea deal with him and that he probably wouldn't have to go to prison, but he was going to get all of these other, this slap on the wrist. But if he didn't comply with his slap on the wrist, then we would, consider reclassifying him as an adult. The evidence further demonstrates that movements were initially advised that defendant intended to enter guilty pleas and were later informed on or about August 22nd of 2025 that defendant would instead enter pleas of no contest. So a no contest plea is just like, I'm not going to admit that I did it, but I know that you probably have enough evidence to convict me, so I'm just going to plead no contest. It's not even an admission of guilt. Movements were present in court on August 25th, 2025, at the time the pleas were entered, and were afforded the opportunity to present victim impact statements. Additionally, counsel for movements and a victim advocate were present during the proceedings, and no contemporaneous objection was made asserting lack of notice or inability to confer. Based on the totality of the evidence, the court finds that movements were informed of plea negotiations and were afforded the opportunity to confer with the attorney for the state. While movements clearly disagreed with the outcome of those negotiations, dissatisfaction with the result does not equate to a denial of rights guaranteed under Oklahoma law. The court finds no evidence of conduct rising to the level of a constitutional or statutory violation. Conclusion: after careful consideration of the evidence and applicable law, the court concludes that movements have failed to establish by a preponderance of the evidence that their rights under Article 2, Section 34 of the Oklahoma Constitution or Title 21 of the Oklahoma Statute 142A were violated. It is therefore ordered, adjudged, and decreed that the verified motion to enforce victims' rights is hereby denied. This was heard by a different judge, Michael Cullig, Payne County Courthouse, and it was signed 3 days ago on April 20th of 2026. If you're from Oklahoma, or even if you're not, let me know how you feel about that. I think it's outrageous. That's my personal opinion. They can't appeal. I don't think they can appeal it further. They may be able to appeal it up, but it's not going to change his sentence, and it's not going to change his plea deal. It's not going to change anything other than, maybe appellate courts are very, very hesitant to overturn judicial discretion. And so what all this was about whether or not the victim's rights were violated. And this judge said no. He said no. See what the local news channel had to say about this. This is News 2 Oklahoma, and maybe they will summarize it in a way that you will. Oops. Oh, please. Let's see if I can get it for you. It's horrific.
We are turning our attention now to Payne County. That's where closing arguments are underway in the hearing for the victims of Jesse Butler. They claim their rights were violated when he took a plea deal. The state argues the victims were notified properly. 2 News Oklahoma's Emma Birch has been in the courtroom all afternoon and all week. She joins us live with the latest.
So this was before the decision came down.
Closing arguments just wrapped up, I'd say about 30 minutes ago, and the judge Cooling has decided that, well, there is no decision just yet. He's actually looking into what the motioners are looking for this application for victims in the future, and that decision will be made later on. Now, this all happened more on day 3 with Assistant DA Deborah Vincent actually going on the stand and testifying, to which she says she actually pushed this filing of the case of Jesse Butler and sought a guilty plea recommending youthful offender charges for Butler due to concerns about trying him as an adult. She says the victims and the victims' families were unhappy with the youthful offender decision. She said that she actually spoke with Butler's attorney, Derek Chance, initially indicating a guilty plea would happen in July, but that changed in August. Just days before the hearing, Chance said that Butler would not enter a guilty plea, rather a no contest plea. She then told the families that was going to happen, that they were upset, but she would try to make changes. The plea deal was finalized that Monday of August 25th when he had pled guilty. Families saying that they just found out minutes before that happened. In the closing arguments, the motioners, the victims' attorneys, I should say, were asking for an apology towards the victims, the way that they were treated, that their rights were violated, and that this new application be sought out to all victims during criminal cases. They say arguing they did not violate any of the victims' rights, especially when it comes to Marcy's Law, that they, under Oklahoma Victims' Rights Act, the state's not allowed or even eligible to give damages towards the victims, like an apology. So the judge has decided that he will have a written opinion. We don't know exactly when that's coming out, but we can assume in a week. And Jesse Butler will actually be back in court a week from Friday. So we'll keep you updated from that. Reporting live outside the Payne County Courthouse, I'm Emma Birch, 2 News Oklahoma.
And that's what's happening in Oklahoma in the case of Jesse Butler. Doesn't look like he's going to be resentenced or anything's going to happen with the plea deal that he already accepted and was granted. And overruled sit down says, you mean the plea deal he's not following because he slept in? Yeah. Remember, he wasn't complying because he slept in one day and he couldn't show up to like probation, and like 2 other times something happened and he missed his Zoom hearings or something like that. Thank you. Thank you, Nicole, for asking everyone to hit the like button. Helps the algorithm. Some golf girl says, again, I'm in Oklahoma, outraged, and his mom, dad, and sister worked or work for OSU Athletics. Stillwater knows that family well. Didn't the father also work at Stillwater High School? Because I remember going over the civil lawsuit that the victims' families filed against the parents and him. And apparently there were some times when he was abusing, or at least one time when he was in the family home, graping one of these girls, and the parents were there. Thank you. Thank you, Keith from Chicago, Illinois. I appreciate you. Elaine says his mother has already advised him not to leave a witness next time. Outrageous. And the school, even though the school was presented with the restraining order that one of the victims had against Jesse Butler, she was still being stared down by Jesse Butler's dad, who did work at the high school. He's the athletic director at the high school. And the mom knocked on the door asking if everything was okay. Lady Bird is reminding me about the civil lawsuit filed by the victims. It's gross. It's horrific. Look in my live streams. I think there's a Jesse Butler playlist at this point. Too. You know, boys will be boys. Let's treat them like a youth and just give them like a year of therapy and, you know, some community service, and then, you know, expunge his record because he didn't even plead guilty. He just pled no contest. So, you know, he doesn't ever have to say that he's a felon or anything or register on the offenders registry, right? It's outrageous. I think he already is in college. If anybody, I don't want anybody, don't say where he goes to college, nothing to, but like there's a video of the kid doing this. Okay. It's not like it's a mystery what happened here. And one of the girls was almost killed. Her doctor said she was something like 30 seconds away from death when she was being choked by him. So welcome to Oklahoma, but it's not only Oklahoma where these things happen, as we know. It's just about everywhere. But before we move on from that, we gotta. I mean, before we move on over to Arkansas, thoughts, questions, comments, concerns. There was a new motion, a renewed motion made in the Aaron Spencer case. Nope, he didn't get any time. He was supposed to get 78 years. They were gonna charge him as an adult, but then they decided some judge gave him a sweetheart deal and decided he should be reclassified as a youthful offender because, you know, he was 17. So he got a year's worth of community service. Year's worth of community service and some, you know, he's got to go to counseling to prevent him from being a rapist anymore. So there's that. Victims in Oklahoma, I'm very, very sorry. It's a sad day for victims in Oklahoma. Right. And that's a good segue over to Aaron Spencer. Aaron Spencer is what will start happening, Lady Bird says, if this keeps happening, taking things into their own hands. Does everybody know about the Aaron Spencer case, or do I need to give you a little summary? We're going to pivot over there in a moment. The shenanigans that have been going on in Aaron Spencer. Megan, thank you very much for your generous $50 Venmo. She says, thanks for all the Karen Reed deep dives. Thank you very, 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 very much. Oops. Summary, please. All right. Let me go to. All right. I'm going to put this to watch later because apparently the Lindsay Clancy hearing did happen. I don't know how long it was, but there is video of it. We can look at that tomorrow. Because Spencer is the last thing that I'm going to cover today. You really need to rest my voice and, you know, do some other things in my life. So, hold please. Let me just find my notes. Seems like it's been a while since we've done a stream on Aaron Spencer, right? Aaron Spencer has now won the primary. He is running for sheriff of Lonoke County, where he lives. His family moved from Florida to Arkansas to care for, I'm not sure who, one of the grandparents. And they've decided to, I guess, stay in Arkansas, but now also they have to await Aaron Spencer's trial. So there's that. All right, let's see. Okay. These are my own notes from like underneath one of my other Aaron Spencer videos, but you gotta get it from wherever you can. Aaron Spencer, 36, is charged with murder in the second degree, a Class A felony, and felony with a firearm in connection with the October 8th, 2024 death of Michael Fossler. Michael Fossler, age 67, had previously been charged with 43 felonies for crimes committed in June of 2024 against Spencer's then 13-year-old daughter, and was released on $5,000 cash bail, but he also got a stay-away order. And on September 4th of 2024, the charges against Michael Fossler were sealed. Fossler's trial was scheduled for December 4th through the 6th of 2024. It's important to point out, Aaron Spencer's daughter was the only witness against Michael Fossler. On the evening in question, October 8th of 2024, Aaron Spencer and his wife awoke to find their daughter missing. Spencer left the house to look for her and came upon Fossler's truck and his daughter in the passenger seat. The scene ended with Fossler's demise, but Spencer saved his daughter's life. Somehow, I think he was able to run them off the road. Fossler was still grabbing his daughter. He got his daughter free. And then, he pumped Michael Fossler full of lead. That's what he did. Okay, what any parent would do. And also what happened was, as Aaron Spencer was leaving to go look for his daughter, his wife called 911 and said, "We have a restraining order against this guy, Michael Fossler, and can you guys go out there and see if you can find our daughter, because maybe he's got her." And he had her. And by the grace of God, Aaron Spencer found them. I think she was 14 at the time. Fossler was dead. Aaron Spencer called 911 after pumping him full of lead and said, "Oh, remember that guy we told you we had a restraining order against? Yeah, here's where he is. You might want to come check on his condition." Charges were brought against Aaron Spencer in Lono County by the district attorney on September 27th of 2024. And by December 10th of 2024, Judge Barbara Elmore issued an unconstitutional gag order in the case, preventing the defendant, attorneys, law enforcement, and potential witnesses from speaking about the case, and she sealed the entire court file. The Arkansas Supreme Court reversed and said it was highly unconstitutional and basically said the judge should be taken off the case. But the gag order was not vacated until June 20th of 2025. A pretrial hearing was scheduled for December 17th of 2025. The trial was supposed to happen in January of 2026. But what had happened was Judge Barbara Elmore was taken off the case. And so everything was pushed. Now there's a new judge. We know also other victims of Michael Fossler have come out. He used to be a police chief in Indiana. And a girl that used to babysit for him, who's now in her 50s, said he did the same thing to me, and his wife was in the room at the time. And then another horrifying thing about that is that the girl, who's now in her 50s, moved to Arkansas. Her mother reported her as a runaway and sent her to live with her father in Arkansas. And when this woman heard about what happened to Michael Fossler, she was horrified to learn that he was living within walking distance from her house in Arkansas. Yeah. Aaron Spencer is going to use self-defense or justification as a defense, and there was a lot of shenanigans that went on with the pretrial motions, and now that there's a new judge and the trial date is going to be in June, Bob and Ali Mata say they're going to go down there for the trial. I'm hoping this judge is going to allow cameras in the courtroom so we can cover it from home. It's supposed to start on the 22nd of June. So we'll see. Now that there's a new judge, Aaron Spencer is asking the new judge to reconsider some of the rulings that Barbara Elmore already made with regard to certain evidence being allowed in. These were motions in limine. We call them motions in lemonade because one time that's what the captions called them. And so we've adopted that phrase happily. So this motion, they've kind of thrown everything together into one. This motion may sound familiar to you because these motions were made before. Okay. That's why they may sound familiar to you. But on April 20th of 2026, Aaron Spencer's attorneys, including Erin Casanelli, we watched Erin Casanelli orally argue in front of the Arkansas Supreme Court, and she was fire. She was fire. This is the state of Arkansas versus Aaron Spencer. This is a motion to reconsider ruling limiting 404A2 evidence, to enter order setting aside prior order as to expert witness, and to enter order granting relief for state's destruction of evidence. Okay. Something else that we learned during these pretrial motions is that the state intends to argue that 13-year-old Aaron Spencer's daughter was in a relationship, a consensual relationship with 67-year-old Michael Fossler. Judge Elmore also precluded an expert who was going to come in and testify on behalf of the defense about grooming, the dynamics between the perpetrator and the victim in CSA cases, and other things, because the judge just said, oh, juries are going to understand that. They already know about that stuff. They don't need to hear about that from an expert. And there was also a motion on destruction of evidence. And so now they are making this motion again, all in one. Oh, yes. And Judge Elmore also said, yeah, you're not going to be able to use any evidence of things that Michael Fossler did to other people outside of the community of Lonoke County. Because as I advised you before, when he was police chief in Indiana, Michael Fossler, there are other victims. And Judge Elmore said, no, it's just, you can only talk about his reputation in the community. They're asking for reconsideration. Here's the motion. Let's go. At this time, Aaron Spencer asked the court to take 3 actions. 1, reconsider and overrule Judge Elmore's geographic limitation regarding reputation and opinion testimony concerning Michael Fossler's character for sexual violence and aggression against women and minors. 2, an order setting aside Judge Elmore's prior order made without any proffer or admission of purported trial evidence or testimony from the expert witness, as she agreed to do at the last hearing over which she presided. And 3, enter an order granting Spencer relief due to the state's destruction of evidence, which Judge Elmore did not rule on prior to this court's appointment in the case. Okay, so she never ruled on the destruction of evidence, but she did rule on the opinion testimony about his sexual violence and aggression in other places, and the expert on grooming and childhood essay. These issues have been addressed at pretrial hearings. Thus, the following transcripts are attached here too for the court's consideration. December of 2025 pretrial transcript and January 23rd, 2025 pretrial transcripts. I have them. There's something like 250 pages long. The entire pretrial hearing transcripts are available. It would be fun to do a dramatic reading of them if I can get some other people to do it with me. All right. Maybe Bob and Allie would want to do it. Hold, please. Don't get confused because, Robin, this law girls is not law girls, not attorneys. Different account, different username. But yes, we do appreciate the law girls, not attorneys. Here we go. These issues have been addressed at pretrial hearings. We have the transcripts. Here's the transcripts. A, this court should reconsider and reverse Judge Elmore's ruling limiting reputation evidence about decedent to his reputation in Lonoke County. Following a pretrial hearing in the above case on December 17th of 2025, the court ruled that the defense would be permitted to introduce evidence pursuant to 404 regarding the decedent Michael Fossler's reputation for violence and aggression. However, this court limited that evidence to testimony about Fossler's reputation only in Lonoke County. Judge Elmore denied Spencer's request to reconsider this ruling. I mean, Erin Casanelli has done everything possible. Footnote 1. The following previously filed pleadings and orders are pertinent to this request. And then there's all these pleadings, which I believe we've been over all of these filings together, but they're listed here for convenience of the court. Arkansas Rule of Evidence 404A2 authorizes admission of evidence of a pertinent trait or character of the victim of the crime offered by an accused or by the prosecution to rebut the same, or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. The rule makes no mention of the word community. Furthermore, limiting Rule 404A evidence, as was done here, does not comport with the Arkansas Supreme Court command that, quote, every fact would be competent evidence in a case of self-defense by the person defended is competent where the killing by the accused is alleged to be in defense of another. Prior to adoption of the rules of evidence, character evidence offered in support of the contention that the decedent was the aggressor or to characterize and explain his acts was, quote, restricted to proof of general reputation in the community where the decedent lived. That's a case going back to 1948, which was prior to the adoption of the rules of evidence. However, no case interpreted this statement as limiting this evidence to the community where the decedent lived at the time of his death. In fact, the rule was that character evidence was admissible if it related to the general reputation of the person in the community or neighborhood in which he lives or had lived. He lives or has lived. After the adoption of the Uniform Rules of Evidence, the court discouraged an overly narrow interpretation of the term community, finding it is not limited in a strict geographic sense. Rather, it includes the person's reputation among his associates, like his employer. Additionally, the court's case law regarding specific instances of conduct within the knowledge of the defendant also made clear that there is no limitation to the specific community where the decedent lived at the time of his death. These are all the arguments they made before. And Judge Elmore didn't agree with any of them. Since the adoption of the rules of evidence, neither Arkansas nor federal law limits character testimony of a person's reputation in the community to only the community in which the offense or trial took place. Rather, courts focus on the character witness's familiarity with the person's reputation in any relevant community. It is my opinion and continues to be my opinion that Aaron Spencer saved his daughter's life that night, because I do not think that Michael Fossler was going to release the only witness against him in his upcoming trial. The geographical limitation imposed by the court here also conflicts with interpretation of the nearly identical federal rule permitting this type of reputation and opinion testimony. And so they are saying that all of the laws in our favor, we should be allowed to introduce evidence that this guy was a violent and sexual predator when he was the police chief in Indiana or anywhere else that he lived in the however many years it's been that he's been doing this. And if the woman who's come forward now is in her 50s, he's been doing it for at least 40 years. And based on my prosecution for the victims of childhood SA against the Catholic Church here on Long Island, I will tell you, the statistics say that a pedo has already offended 100 times before they're ever caught. Those are the statistics. Just facts. person's character does not change merely because they happen to leave a certain community. A violent person is still a violent person even when they move out of state, just as a peaceful person is still a peaceful person even when they leave the town on vacation. Fossler's reputation for violence and sexual predation of women and minors in the communities in which he lived is admissible, whether that was Indiana, Pulaski County, or Lonoke County. Moving somewhere to get a fresh start does not absolve one of their reputations in the communities in which they lived up to that point. Additionally, a Lonoke County jury will be capable of giving any evidence of Fossler's reputation in communities outside of Lonoke County the weight such evidence is due. And so, faith in the jury in Lonoke County. Because the prior ruling is inconsistent with the law, this court must reconsider the ruling and rule in our favor, saying that we can use whatever evidence we want for wherever this guy lived for whatever time. B, this court should enter an order consistent with Judge Elmore's oral determination, setting aside her order excluding defense expert witness Carrie Landau. The state moved to exclude all defense experts on general grounds. See November 13th, 2025, state's motion in limine to exclude evidence. Here's another, just, food for thought. I say this all the time, and Mark Betterow says it too. Shouldn't a prosecutor's job be about finding the truth and not just trying to get a conviction? Shouldn't a prosecutor have some intellectual curiosity to find out what really happened, what the facts really are, what the expert witnesses have to say? Because why would the state move to exclude all of the experts of Aaron Spencer? Because they're afraid that a jury might believe what the experts have to say. They did the same thing in Karen Reed's case, right? And do you remember the Daubert hearings that we had to watch, that Karen Reed had to pay for the crash daddies and for Dr. Russell to fly in and be questioned, for days when they were clearly qualified as experts? It's wild. It is their actual job, but they don't care. They just want a conviction. Oh, please. Not all, but some. We have also seen some very good prosecutors in the cases we have covered. One of whom that I remember is Michael Daugherty, Boulder, Colorado District Attorney. We watched some of the King Soopers mass shooting murder case. And Michael Daugherty is an amazing guy with a lot of integrity who tried that case fairly. And turns out Michael Daugherty was worked in the Manhattan District Attorney's Office with Mark Betterow. They like that. All right, moving on. On consideration at the first pretrial hearing, Judge Elmore commented that Landau's testimony was only trying to confuse the jury and bring in things that they do not need to hear any more of. Oh, thank you, Christina, for your Venmo. She says, because you're a groovy chick. Oh, thanks. I appreciate you so much. On December 29th, 2025, Judge Elmore entered an order excluding expert witness Carrie Landau's testimony, finding that her testimony will confuse the issues in this matter and would not assist the jury in this trial of homicide. After Spencer moved twice for reconsideration on January 23rd, 2026, Judge Elmore scheduled another hearing. At the hearing, Judge Elmore agreed that contrary to her prior order, Landau's testimony was not excluded from trial, but instead, that as Spencer requested, the court would consider the testimony after having heard evidence at trial. And it's in the transcript. Judge Elmore indicated she would draft an order so confirming. However, later that day, before she entered a written order, the Arkansas Supreme Court removed Judge Elmore from the case. Well, divine timing, huh? Footnote 3 reads, this order also included the testimony of Jennifer Steele. Despite that, exclusion of this testimony was not addressed at the pretrial hearing because the witness was unavailable due to a family emergency. The order also commented on the testimony of Clint Norris, although the state did not pursue exclusion of his testimony at the hearing. Yes, he is being tried in Lonoke County, which is the same county that he won the primary in, because he's now running for sheriff. Like you're asking P. Lola's mom. Thus, because she was removed by the Arkansas Supreme Court, she did not get the chance or opportunity to enter an order consistent with her oral rulings. Carrie Landau, I believe she is the expert, right, on the childhood essay and grooming. Maybe they'll get into this here. Maybe they won't. The associated legal issues, details of her testimony, and procedural status are outlined in several previously filed motions, right? But she is the expert on childhood essay, the grooming process, how pedos do it, how they try to convince the child that they're in a real relationship, all kinds of things like that. Testimony of this sort is clearly admissible to assist the jury in understanding the evidence in cases involving the essay of minors. And that's what expert testimony is about. As expressed at the hearing, Spencer asked this court to enter an order consistent with Judge Elmore's statements at the hearing that the order excluding Landau's testimony is set aside, and the admissibility of Landau's testimony will be determined after the court has heard the evidence presented at trial. So I guess they will do a proffer or whatever they call it in Oklahoma prior to her testimony. Call her in for a Daubert hearing. I mean, I might have amended that to say, can you just rule that it's admissible? But I trust Aaron Gassinelli. C, the court should enter an order granting Spencer relief for the state's destruction of material exculpatory evidence. On November 25, 2025, the defendant filed a motion for an adverse inference jury instruction and hearing on spoliation, destruction of evidence, which requested a spoliation instruction, a hearing to establish the circumstances of the spoliation, and a determination of an appropriate sanction as a result of those circumstances. Footnote 4. Spoliation is just a fancy way of saying the state destroyed evidence that would have been good for us. And they lost it. They destroyed it. Something happened to it. And the jury should be instructed that if you find that the state lost, destroyed evidence, you may infer that that evidence would have been exculpatory for the defendant. The wording differs depending on what state you're in, but I'm summarizing. Footnote 4 just gives the judge all of the pleadings and transcripts pertinent to this request. At the hearing on this motion, Spencer's counsel asked for relief in the form of dismissal, restricting the state's evidence and or a spoliation instruction. Although Judge Elmore conducted a hearing, she did not enter an order as to this motion before being removed from the case. Spencer reaffirms his request and asked this court to enter an order dismissing this case on the ground that the state's destruction of exculpatory evidence violated his due process rights. If the court declines to impose dismissal as a sanction, Spencer asked the court to impose an evidentiary sanction and or permit an adverse inference jury instruction related to the spoliation of the evidence. Spencer also asked this court conduct a second hearing on this issue if it would assist the court to make its own assessment of certain witness testimony and or hear the parties' arguments as to the evidence presented as applied to the law. Okay. All right. Here comes somebody trying to convert us to their religion. Thank you, Scott. You know what to do. You think it's a bot? Because it's been happening a lot. It's weird. It's weird. I don't know. They misspelled destroyed. And I can't look for that now. I'm getting tired. I gotta get through this. Okay. The evidence at the hearing includes substantial detail and requires assessment of the testifying witness's credibility. Spencer will include a very brief overview here, but this does not include all the facts and inferences developed at the hearing and should inform the court's assessment. It is instead just to give the court an overview of the issues involved that are more fully addressed in briefing and in the hearing transcript. During this hearing, as to the dash cam's handling, the court heard the testimony of Lono County Sheriff's Office's Deputy Dakota McCraney, Detective Robbie McCain, Sergeant, and they spelled Sergeant wrong too, Carla Lucas, and Lieutenant Giacomo Portali, Giacomo Finane. Detective McCain was the lead investigator assigned to the case, meaning that the area of the incident was considered his crime scene, and he was responsible for photographing and collecting the evidence. Thank you, Robin, for gifting 5 memberships. I appreciate you so much. Detective McCain was the lead investigator assigned to this case. I just read that part. The testimony of McCraney and McCain are inconsistent as to when the dash camera was located. During the hearing, and I think, is this the dash camera from inside Fossler's truck? I think it is. And it would have shown what was happening inside the truck. But wait, there's more. If anybody remembers, let me know. Thank you. I'll allow it. Says yes. Okay. During the hearing, Deputy McCraney testified that he left the scene of the incident around or before 4 a.m. And that was in the transcript. Later in the hearing, Detective McCain testified that Deputy McCraney informed him of the dash camera's existence right before the tow truck arrived around 5:35 a.m. This is a discrepancy of 1.5 hours, which is particularly significant given the state's inference that the video was actively recording over itself during this time. Oh. Additionally, officials on the scene were instructed to turn off their body cameras, making it impossible to determine the time at which the dash camera was located and collected. Wow. Right. It's the dash cam from Michael Fossler, the pedo's truck, in which he was kidnapping Aaron Spencer's daughter. Not only is it impractical and antithetical to the purpose of a body camera, but it is also against the Lono County Sheriff's Office written policies to instruct deputies to turn their body cameras off. When Detective McCain collected the dash cam at some point between 4 and 5:30 a.m., he did not photograph its position or its location, nor did he document its existence in his incident report. Wow. I mean, they're up there with the Canton PD and the MSP assigned to the Norfolk County DA's office in Massachusetts, huh? This failure to photograph and document the dash cam constitutes a violation of Lono County Sheriff's Office policy for handling evidence. During the hearing, Detective McCain admitted that the camera was not logged into evidence, but was instead stored in his personal office rather than the evidence room, explaining only, quote, "It was an oversight on my part that it wasn't logged into the system and it got missed." Wow. Wow. Okay. If you want to do a deep dive into the corruption in Lono County and Arkansas in general, there's a really great channel for you. Somebody tell me the name of it because I can't think of it right now. But there's a guy who has a YouTube channel that has done such a deep dive into the corruption in Arkansas. And we can shout him out if somebody tells me in the chat. The dash cam was not logged into evidence until over a year after it was collected. Another violation of the Sheriff's Office evidentiary policy. No, it's not Tony Bruschi. It's a guy from Arkansas. I'll find it for you. According to his testimony, Detective McCain removed the memory card from the dash camera before logging it into evidence and viewed its contents on the computer in his personal office. Nope. Not the Random Patriot. Nope. I'll remember it when I hear it. When asked whether removing memory cards from electronic devices was regular practice, Detective McCain stated this was the first dash camera the Lono County Sheriff's Office has ever seized during an investigation. But further asserted that it is their practice to remove memory cards from game cams, like hunting cameras, which the Sheriff's Office allegedly use and view in office as regular evidence in theft investigations. You guys are telling me there's more? This is a cold read for me. After viewing the contents of the memory card, Detective McCain testified that he placed the card back inside the camera, placed the camera in an untaped envelope, and put the envelope in his office cabinet rather than logging it into evidence. Carnage on Ice. Thank you. Thank you. It's Carnage on Ice. That's the name of the YouTube channel. Thank you very much. Very, very, very deep dives into Arkansas corruption, Lono County corruption. Thank you. On November 14th of 2024, Sergeant Carla Lucas took the dash cam from the Lono County Sheriff's Office to the Attorney General's office for examination. The Attorney General's office did not receive the SD card containing the data from the dash cam. Additionally, the evidence log incorrectly represents that the dash cam was transferred to the AG's office 1 month before it was, which Detective McCain chalked up to a clerical error. Oh, I'm surprised he didn't say Scrivener's error. Footnote 5 refers to Exhibit 7. None of Detective McCain's actions related to the dash cam were documented in any database or log, which is a violation of the Sheriff's Office written policies. By his own admission, Detective McCain's failure to place the dash cam into evidence resulted in the camera not being logged into the system of evidence for over a year. In fact, there was no mention of the existence of a dash camera in any discovery or law enforcement documentation until it was returned from the AG's office on October 16th of 2025, when Detective McCain decided to enter the dash cam into evidence as item E85. Wow. The testimony confirmed that the Lono County Sheriff's Office typically sends electronic or digital evidence, such as computers and phones, to the AG's office for examination. In this case, with the exception of the dash cam, the Lono County Sheriff's Office sent all other items, including memory cards, phones, computers, tablets, and other items of digital evidence, to the AG's office without first attempting to view them in office. Well, that's interesting. So the only thing that they looked at before sending them over to the Attorney General was the same thing that was never logged into evidence and that has now gone missing. Well, that's interesting. And sus. It was sent to the AG's office because it says that that's what they typically do. They typically send, the Sheriff's Office typically sends electronic and digital devices such as computers and phones to the AG's office for examination. That's what they do. That's their procedure. In addition to the general mishandling of the dash cam evidence, Detective McCain's testimony regarding what he purportedly viewed on the memory card was impossible based on the camera's functions. McCain did not document accessing the SD card or what he supposedly saw when he did so. However, Detective McCain testified that he saw between 2 and 5 folders when he accessed the dash cam's footage, and that one of those folders contained 4 video files. He further testified that 3 of the video files were roughly 15 minutes in duration, while the 4th video was a little shorter. Okay. Brandon Purchase is a specialist in cybersecurity who examined the camera and its functions, testified at the hearing. Mr. Purchase's examination of the dash cam revealed that it records audio and video from two separate cameras that record simultaneously when the camera is plugged in. The main front-facing camera and the rear swivel camera. During his testimony, Mr. Purchase explained that it was impossible for the dash cam to create the format and length of videos Detective McCain alleged that he had seen. Specifically, Mr. Purchase explained that the dash cam was only able to produce two folders, one containing data from the front camera and one for the secondary lens's data. Mr. Purchase further testified that the dash cam can only capture video in increments of 1, 2, 3, and 5 minutes. The dash camera was incapable of producing the 2 to 5 folders and 15-minute videos that Detective McCain testified about, regardless of the type of memory card inserted. Wow. Detective McTaint. All right, resisting arrest. Motion granted. Proctored the evidence and lied under oath. Michael was waiting for it and says, there it is. Oop, there it is. Robin gifted another 5 memberships. Thank you so much, Robin. In spite of the confusion as to when the dash cam was located, the mishandling of the dash cam, and the impossible assertion regarding the contents of the videos on the dash cam, several members of the Lonoke County Sheriff's Office who testified at the hearing acknowledged the evidentiary significance of the dash cam. In fact, both Deputy McCraney and Detective Lucas answered in the affirmative when asked if they immediately recognized the dash cam as an item of evidentiary value. There is also no logical or legitimate argument that the dash camera would not provide exculpatory evidence, including Fossler's custody of Spencer's daughter, Fossler's directives to his victim in the truck, Spencer's attempts to get Fossler to stop his truck, and Fossler's refusal to do so, Fossler's active fleeing from Spencer with Spencer's daughter in his control, Spencer's successful effort to safely maneuver Fossler's truck into a driveway, and Fossler's aggressive exit, including the language he used when he exited the vehicle, among many other things. Well, I mean, should this case be dismissed based on this alone? This dash cam had an interior camera and an exterior camera that would have shown all of those things that we just read, which would have probably, likely, very likely, bolstered Aaron Spencer's defense that he was acting in defense of his daughter when he killed Michael Fossler, including audio. It had video and audio. Lies, lies, lies. Yeah. Robin gifted 20 more memberships. There's somebody who really, really wants a membership. And then Robin's really, really, really trying so hard to gift this person a membership, but you can't choose who gets it. So thank you, Robin. Thank you, Robin. And good luck to whoever that was I just saw fly by. Dismissal is a harsh remedy. We know that. Judges are hesitant to do it. But based on all of the other shenanigans that went on in this case, including the Arkansas Supreme Court coming down on this case twice and removing Judge Elmore from this case, Robin's awesome. Despite its obvious and immediately apparent evidentiary and exculpatory value, Detective McCain did not make any reasonable efforts to preserve it. Consistently handled it in a manner that violated all of the policies of the Lonoke County Sheriff's Office, failed to document any of these events and errors, and cannot provide any explanation for its loss. His actions destroyed this evidence. This was not a single violation of policy. It was a pattern of policy violations that destroyed critical evidence which warrant relief. Wherefore, the defendant, Aaron Spencer, respectfully requests this court enter orders as we have set forth herein, and XOXO respectfully submitted. Aaron Casanelli, Michael Kaiser of Lassiter and Casanelli. I really, really, really hope that the new judge here will allow cameras in the courtroom because the world needs to see what's going on in Lonoke County, you guys. Carnage on ice, can't expose it all, but he's been exposing a lot. Robin's making it rain membership. Paola also gifted 10. Carmen knows your address, became a member. Welcome. Thoughts, questions, comments, concerns before we wrap this one up for today after only 3.5 hours. It's like a half a day. It's like a half day. It's like a half day today. But we stumbled upon the Karen Reed hearing that we didn't know was happening. So that was good. We stumbled upon the fact that Ken Mello has been arrested for threatening to stab a nurse in Fall River. Ken Mello, the special prosecutor of Aiden Carney. I mean, this is so crazy. All of this is so crazy. I wish I could say I couldn't believe it, but I believe it. I absolutely 100% believe it. Just when you think it couldn't get any crazier, it is getting crazier. Well, 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 you can never tell. All righty. We are moving on. We're moving on. Got to go rest my voice. I think we'll do something tomorrow, but you know, just plan for like noon, unless I'm just so exhausted that I can't do it. Because I've been here every day this week, and we did like over 20 hours of coverage, I think, or close to 20 hours of coverage on the defamation case against Karen Reed and Aiden Carney. Okay. Anybody else? Anybody else? Charissa gifted 5 memberships. Thank you, Charissa. You're a sweet pea. And then Friend of Dog gifted 10 memberships. You guys, I love you so much. I love you so much. So if you missed everything that happened today, it was like explosive, all the stuff that happened. All right. Let's go Avs. Let's go Bruins. Hockey starts at 7 p.m. tonight. It's a full throated night of hockey, everyone. So it's my favorite season, playoff hockey season. Go Buffs. Stay cool, stay kind, stay classy. Stay off the internet if you can. Don't believe everything you read on the internet. Thank you, moderators. I couldn't do this without you. I love you so much. Let's go. Oh yeah, the Vegas Golden Knights. Tortorella is your coach. Tortorella used to coach the Islanders. I am kind of rooting for you guys too, because of torts. All right, guys. I love you so much. I will see you very soon. But you're going to have to make sure you have your notifications set, because YouTube is not sending out notifications purposely. They did a whole creator update on it. And the reason they're not sending them out is if you have not engaged with a channel or engaged with a notification for a channel for a month, they're not giving you notifications anymore because they don't want you turning off all notifications for all channels. I don't know. It's weird. I don't like it, but they didn't ask me. Emily Baker is meeting, I think, with YouTube this week. Hopefully they can ask her, and hopefully maybe she can fix it, but I don't know. All right, you guys, I'll see you really, 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 really soon. If I don't see you soon, I'm going to die. Bye.